Yes, the Lordship. My Lord, I filed for listing. The urgent matter is that around 30th of April, they issue the demolition order. So given the 7 days time, so yesterday we filed. So my Lord may be allowed on the day after tomorrow. Much.
May it please your Lordship, we are making a joint prayer for adjournment of item number 10, Lordship.
10.
Yes, Lordship.
Yes.
After 4 weeks, Lordship.
Why? This is
Lordship, because there is a compromise talk going on, Lordship. That is.
okay.
I've been.
Miss R.D. Mozumdar, learning counsel for a petitioner, and who is for the respondent? Miss
MSP
Miss P.J. You are representing whom?
on behalf of Mr. S.P. Roy.
Learning counsel representing Mr. S.P. Roy for the private respondents. Private respondent.
State is informed, Lordship.
Have conjointly submitted that the case be listed after 4 weeks as a compromise talk is going on between the parties. Full stop. In view of the ground cited for adjournment, the prayer is allowed, leave the case out of focus.
Highly obliged.
May please your Lordship. I am mentioning for requisition of the affidavit which I have filed yesterday, my Lord. The matter is not today, my Lord, day after tomorrow, item number 5. Affidavit requisition.
You raise there.
May it please your Lordship, with the concern of the other side, my Lord, I beg to mention item number 12, my Lord. I'm paying with my password for a day, my Lord.
You are for a petitioner?
It is my Lord.
Okay. Mr. R.S. Mitchell, learned counsel appearing for the petitioners has made an adjournment, made a prayer for adjournment of the case for a day. It is submitted that consent has been taken from the learned counsel for the respondents to make the prayer. The prayer is allowed, is that the case is passed over for a day.
Deeply obliged.
May I please your Lordship? Lordship, I beg to mention for listing of a writ petition on 16/5/25, which was last posted on 12/3/25.
What is the subject matter?
Lordship, it relates to pharmacy council election.
16. Okay.
Obliged, Lordship.
May it please your Lordship, I'm paying for listing of a motion matter for Friday, my Lord.
Friday, you have filed
Yes, sir, file.
subject matter?
GST concession,
It will be listed.
my Lord.
Normal course.
My Lord, obliged, your Lordship.
May it please your Lordships. Lordships, adjournment request was circulated with regards to item number 2 with due consent of the other side, your Lordships.
Okay.
Lordship, Senior Counsel K.N. Chaudhary is unavailable today.
You are Mr.
T. Kashyap, your Lordship.
T. Kashyap, learned counsel, appearing for a petitioner. For the petitioner has made a prayer for adjournment. It is submitted that consent has been taken from the learned counsel for the respondents to make the prayer. First of how much?
Lordship, the
Place the case
Counsel-
after a week,
much obliged.
on need to be fixed by others. Any interim order?
Lordship.
Silo.
Much obliged.
Daily list for motion, item number 1.
Please, your Lordship, we have received the instruction. Let me be file the affidavit in the
Okay. Then you issue notice then.
My Lord, then I'm paying for stay also.
Hmm?
I'm paying for interim also.
On what ground?
My Lord, I have taken 2 grounds, my Lord. First, my Lord, my prayer for installment was rejected, my Lord. And second, I'm also challenging the procedure because, my Lord, section for purpose, there was no adjudication, my Lord. They sent a letter that this much amount is payable by you. Then, my Lord, initially we disputed, then we made application for installments. That was rejected. And in every letter, my
So
Lord.
for installment, that is as per the statutory provision they have rejected,
No, my-
because they have no power. They have no power
my Lord.
other than what is provided in section 80.
24 they can grant, my Lord.
Huh?
At least 24 they can grant.
24 running into how much period? What
For
period?
24 equal installments, my Lord.
Huh?
24 equal installments.
What is the section?
Section 80, my Lord.
Now, what is your case?
my lord. Respondent number 3 issued a letter at page 19, my lord.
Hmm.
Stating that for the financial year 2018-19, there was a delay payment of tax, therefore interest is payable around for 38,55,000, my lord. It is given a chart, my lord.
Scrutiny of return. Okay, there was late fee
Late fee.
and interest on late payment.
Late fee we are not disputing, my lord.
Hmm?
Late fee we are not disputing, my lord. Interest amount, no, they have asked 38 lakhs for the financial year 18-19.
Hmm.
This letter was issued by respondent number 5, my lord.
Hmm.
Then, my lord, next page, my lord, page 20, my lord. It was issued by respondent number 3, my lord. They were also they were also seeking payment of interest. They are seeking interest from 2018 till March
This is
22.
Dibrugarh, Sivsagar.
One is
So
paying,
this superintendent is under
there is, the,
Commissioner Dibrugarh.
my lord.
Okay. This was in 26/10/2023.
My lord.
Okay.
Then, my lord,
Then next is page 20.
Page 20.
When, what is the date?
it is my lord,
29/11.
29/11, my
Hmm.
lord.
Yes, what
It
is
was
there?
They were seeking the interest for the period from April 18 to March 22, my lord.
Now they have quantified it
Yeah.
at 96 lakhs.
96 lakhs, my lord.
Interest on delayed payment of tax
Yes, my lord.
under section 50.
50, my lord. My lord,
Yes, dates are mentioned on avail unutilized ineligible ITC,
that part we are not disputing, my. We have paid that part, my lord.
non-payment of interest.
Interest, my, with regard to interest only, my lord. My
You
lord,
have failed. This ITC part is 8,79,000.
yes, my lord. That we are not disputing, my lord.
Hmm?
That we have paid, my lord, already.
You have paid
Paid. That we have paid.
after receipt of this notice.
Yes, my lord. We have paid.
When?
My lord, That I have not mentioned the petition, my lord. That I have, that's why I have not disputed my petition, my lord.
Hmm?
That's why I am not disputing this part in my petition, my lord. Only interest part, my lord.
Now interest part is
Hello.
1 crore 24 lakhs. Out of that, 8 lakhs paid.
Paid, my lord.
Hence net amount due
96 lakhs, my lord.
is 96 lakhs according to their calculation.
Yes, sir. And they say, my lord, if I do not pay,
So
my lord,
there are two parts in
My-
the notice.
my lord,
Annexer B,
my lord.
8,79,904,
Yes, my lord.
right?
Yes, my lord.
This is input tax credit.
My lord.
The other part is 96 lakh 6,286.
My lord.
That is delayed interest on delayed.
Payment, my lord.
Payment of tax
My lord.
under section 50.
My lord.
Then what happened?
But then, my lord,
What did you reply?
with regard to, my lord, the letter issued by.
This is a note, this is what? Compliance, okay, directed, notice.
Notice, my lord.
Failing which
They will issue,
show cause notice will issue.
Issue.
Then what did you reply?
my lord. My lord, we made an application, my lord, before the commissioner at page 32, requesting that this 96.
What is this, page 25?
25 is a reply to the range office, my lord, that it was replied.
Okay, this has no, not much of relevance.
Then,
Then next,
my lord,
when did you reply to this annexer B?
annexure B, my lord,
Hmm.
we didn't reply, my lord. We simply made an application before the commissioner saying that, my lord, there is that the respondent is asked to make payment of 96 lakh.
Let us see your reply.
My lord. Page 32, my lord.
First, you will let us see 26.
My lord, sorry.
This mine. Commissioner. Certain as paper. This is a reply to the superintendent.
Superintendent, range office, my lord.
No, what did you reply to this? Page annexer B.
Annexure B, my lord. Annexure B is.
What is page 29 again?
My lord, coming, my lord. Page 29 is issued by, again, by superintendent, my lord, respondent number 5, my lord, who has issued annexure B, my lord.
Annexer B, okay, and annexer C.
C.
Annexer C. What did you reply?
My lord, to this, my lord, no reply was submitted, my lord.
Hmm?
To this, my lord, reply was not submitted, my lord.
Then
We made an application to the commissioner saying that.
this
respondent number-
is annexer C is by whom?
It is by respondent number 3, my lord.
This is, who is he?
He is the deputy commissioner, my lord. Sorry, superintendent anti-evasion,
Anti-evasion.
anti-evasion, my lord.
Okay, did you reply to this?
my
No.
lord. We,
Then
my lord, we wrote a letter to the commissioner, my lord, who is the competent authority for allowing installments, my lord. That is at
let us see your page 32.
32, my lord.
$29.11. There is no mention about this. 2911, okay.
It is there, my lord, reference is
Okay.
there.
The So you need 48.
my lord.
48 equivalent monthly installment, which is against the statutory prescription.
My lord.
Then what did they reply?
Page 34, my lord.
Because you have admitted 96 lakh there.
My lord.
Now, how this figure 1 crore 24 lakhs came?
My lord.
Where from?
My lord, it is in page 20, my lord, in HSC.
Which part?
My lord, page 23, my lord. Total column is there. Below, my
Total
lord.
column.
Page 23, my lord.
Okay, this is interest on delayed payment.
Let me, my lord.
Huh. One crore. So your claim was 28 lakh, but it was found at 19 lakh.
But they themselves claim 28 lakhs, my lord. In the letter itself, my lord, page 20, NHRC, my lord.
Right?
Yes, my lord.
But there can be clerical mistake
Yes,
also.
okay, my lord, that is there. my lord.
Then ultimately it is 90 lakh, 19 lakh
My lord.
instead of 28 lakh.
My lord.
Actual balance is 1 crore 5 lakh.
My lord. The reason for
Yes, no, if you have asked for 48, which he is not authorized.
my lord.
Had you asked for 24,
My lord.
it would have been a different thing. You asked for something which is not authorized. How can he reply?
The reason for rejection was that, my lord, it is there in first paragraph, my lord. They did not say for 48 installment. They say, my lord,
48, it is there, page
Ah.
34.
now, yes, now, my lord, what they are saying
It is
is
not
that
approved by the competent authority.
as the interest liability of rupees 1 crore 24 lakh 6,286 is due as
And still say such amount is not eligible for payment in monthly installment in terms of section 80.
80. Now, my lord,
80.
section 80 says
80 is 24.
not 24. It is there. They are saying it was
No,
self-assessed liability.
when you ask for
My
something,
lord,
you should be asking for it within the four corners of the law.
that's true, my lord. That is
When
true,
you are asking something which is beyond the four corners of the law, how can he
my lord.
permit it?
That is true.
If he allows, then he will be proceeded disciplinary proceeding will be drawn against him.
No, we want to deposit in 24 installments. Now we are agreeing, my lord.
48 is not permissible.
Not 24. We want to deposit in 24, my lord.
Now, after lapse of 1 year, 2 year, you are saying that 24 now. So then there is nothing wrong.
But if that's my lord,
You have admitted
my lord,
about 1 crore 5 lakh,
my lord,
right? Or initially 96 lakh.
96 lakhs, my lord.
You claim that 20 lakh paid. Ultimately, they have found that it is 19 lakh.
My lord.
Still, they have asked, they are asking it
My lord.
that please provide if you have paid 28 lakh. So you are silent. Now, what is the wrong?
No, my lord, that's why I'm plus this court
No wrong.
allowing for 24 installments only, my lord. For 24 installments only. Otherwise, my lord, this entire business will be held.
No, you should have answered immediately. Now, why court? Why court? What? Your petition appears to be a mercy petition only now. What I could gather,
My lord.
nothing more.
Only 24 if lordship. Ask me.
Because notice is also in tune.
Yes, my lord.
Notice is also in tune with the finding they have reached, and you have not disputed anything.
Or lordship may allow me a liberty, my lord. I can make a fresh application seeking 24 installments to them, my lord. They may consider, my lord, as per section 80, my lord.
Hmm.
That if lordship permits, my lord.
Yes, that you can seek indulgence.
My lord.
But otherwise, I am
That's my-
finding no wrong.
That's for
Everything is admitted.
Lordship may allow me.
Question
liberty-
of interim prayer is also.
The lordship may allow me to make an application before them, seeking 24 installment as per section 80, my lord, and they may consider my application, my lord.
Lordship.
Yes,
Since GST.
we are disposing of
My lord.
hard. Where is Mr. Kyle?
That's in court number 1.
R.S. Mishra. Learned counsel for the petitioners. Mr. B. Chakraborty, Learned Central Government Council. For the respondent number 1. Mr. K. Jain, Learned Counsel representing Mr. S.C. Kayal, Learned Standing Counsel, Central Goods and Services Tax within bracket CGST. For the respondent number 225. Full stop. The petitioners have approached by the present petition instituted under Article 226 of the Constitution to assail within bracket prayer portions of a notice bearing number so and so dated 22/10/2024 issued by the respondent number 3 and a notice number so and so prayer 2 dated 28/11/2024 24 perhaps.
My lord, sorry, excuse me.
Huh?
24, I am sorry, my lord. That's the thing.
Annexer J. J. Dated 28/11/2024 issued by the respondent number 3. Full stop. There is no prayer for also installment. Para. The petition number 1 is a partnership firm having its registered office at Rangpur Nagar, district Sibsagar. And the petition number 2 is the managing partner of the petition number 1 firm. Full stop. The petition number 1 firm is engaged in the business of execution of contracts of housekeeping services, etc. And it is registered under the provisions of the Central Goods and Services Tax Act, CGST Act, 2017. On and from 1/7/2017. Full stop. The petition number one firm was issued a GST registration certificate bearing registration number, page 16, on 26/9/2017. Full stop. Para. As the petition number one firm, within bracket, the petitioner firm also is liable to pay tax under the CGST 2017. The respondent of five after scrutiny of the returns for the tax period colon 2018-2019 submitted by the petitioner firm, comma, issued a notice on 26/10/2023 finding certain discrepancies. Postal. In a notice, comma, it was informed that on scrutiny of returns, it was found that the returns had been filed beyond the due date. And as a result, comma, the petitioner firm was found liable to pay late fee under section 47 of the CGST Act, and also interest on late payment of the taxes under section 50 of the CGST Act during the tax period colon 2018-2019. Full stop. The late fee, the amount towards late fee was quantified at rupees 1,13,850. And the amount towards interest on delayed payment of tax was quantified at 38,55,335. Full stop. By the said notice, comma, the petitioner firm was directed to explain the reasons for the discrepancies so found by 27/11/2023. Full stop. It was further informed that in the event no explanation was received by 27/11/2023, comma, it will be presumed that the petitioner firm had nothing to say in the matter, and proceedings in accordance with law would be initiated against it without making any further reference. Full stop. Para. Thereafter, comma, on 29/11/2023. Respondent number 4 issued a notice to the petitioner firm in form GST DRC-01A Under rule 142 within bracket 1 capital A bracket close of the CGST rule 2017. Full stop. In the said notice, comma, it was informed to the petitioner firm that it had that investigation revealed from the GSTR-3B returns for the period from June 2018 to March 2021. That the returns were filed after the due dates for availing input tax credit. And according to the revenue authorities, the same were ineligible in terms of section 16 within bracket 4 of the CGST Act. Full stop. The amount was quantified at rupees 8,79,904. Full stop. In addition, comma, the notice stated that from the records, it was revealed that during the tax period from April 2018 to March 2022, the petitioner firm had failed to pay the tax to the exchequer within the period prescribed and filed the returns in GSTR-3B after due dates, but did not pay the applicable interest under section 50 within bracket 1 of the CGST Act. Full stop. In the notice, comma, the amount calculated towards interest under section 50 within bracket 1 of the CGST Act for delayed payment of taxes was quantified at rupees 1,24,06,286. Full stop. It was further informed that from the records, it was revealed that is an amount of rupees 28 lakh during the financial year 2018-2019 was deposited through form DRC-3, and hence the net amount of interest for the period from April 2018 to March 2022 would be rupees 96,06,286. Full stop. By the notice, the petitioner firm was requested to pay the amount of tax rupees 8,79,904, along with the amount towards delayed, along with rupees 96,06,286 towards delayed payment of taxes under section 50 within bracket 1 of the CGST Act. Full stop. It was further informed that the compliance should be submitted by 1/12/2023, failing which show cause notice should be issued under section 74 of the CGST Act. Full stop. The petitioner firm initially replied to the response number 5 on 12/12/2023 in response to his notice dated 26/10/2023. Full stop. As well as full stop. Subsequently, another reply was submitted before the respondent number 5 on 27/2/2023, right?
My lord.
Full stop. Para. This page 29 is by whom?
The correspondent number. My lord.
Thereafter, comma, the respondent number 5
Sorry, 5 minutes.
had
Second.
issued a notice to the petitioner firm on 19/1/2024, intimating the outstanding liabilities found against the petitioner during scrutiny for the financial year 2018-2019. Full stop. The petitioner firm, in response to the notice in form GST DRC-01A, issued by the respondent 4. After receipt, the petition after receipt, submitted a representation before the respondent number 2 on 6/2/2024 with a prayer to allow the petitioner firm to deposit the amount intimated by DRC form DRC-01A dated 29/11/2023 through (48) equal monthly installments full stop. The representation of the petitioner firm dated 6/2/2024 of the petitioner firm was responded by a letter dated 22/10/2024. Full stop. In the said letter issued under the hand of the respondent number 3, the petitioner firm was informed. This is different. This is another letter.
No,
This
madam.
is,
But they have.
you
mentioned
submit
one-
another letter.
No, only one, my lord.
Then why then
It is-
page 34?
It is a wrong reference.
16/5.
It is a wrong reference, my lord.
Uh-huh.
It is a wrong reference because we have given only one letter, my lord.
Equal 9/2, just about last 9/2. In the seed letter, the petition firm was informed that its prayer, its request to allow the deposit in its request to deposit the amount claimed via form DRC GST DRC 01A in 48 equal installments was not approved by the competent authority. Post up. It was mentioned that as the interest liability of rupees 1,24,06,286 was due as per the liability self-assessed in the returns from April 2018 to March 2022. Such amount was not eligible for payment in monthly installments in terms of Section 80 of the Act. Full stop. It was further informed that the petitioner firm would be liable to pay interest of rupees 1,24,06,286. No, no. Line correct. The petitioner firm was informed that on verification, on further verification of the payment particulars, it was noticed that the petitioner had paid only an amount of rupees 19 lakh, though it was earlier informed to be rupees 28 lakh. Full stop. With such observation, the petitioner firm was informed that the petition, it would be liable to pay an amount of rupees 1,05,06,286 under Section 50 of the CGST Act, and such amount was demanded within a period of 7 days from the receipt of the letter dated 28/10/2024. Post. It was further informed that non-deposit of the due interest might lead to initiation of appropriate action under Section 79 of the CGST Act and the rules made thereunder. Post. In response to the above notices from the respondent authorities, the petitioner firm, on 18/11/2024, raising certain grounds, sought withdrawal of the letter dated 28/10/2024. But, the respondent authorities by this letter dated 28/11/2024, issued under the hand of the respondent number 3, had reiterated its demand to pay the amount of rupees 1,05,06,286. First of the same was followed by the notice, by the summons, by a summons dated 6/1/2025. Issued in exercise of the powers under section 70 of the CGST Act. Post of para. From the table annexed in a form as GST, in a notice issued in form GST DRC 01A. In the table. The respondent authorities had provided the details month-wise regarding filing of the returns in form GSTR-3B. Post of. The table had further provided the calculation of interest against the number, against the days, against the delay period in days in filing the GSTR-3B returns. Post of. The petitioner firm has nowhere disputed the calculation of the amount demanded towards delayed payment of taxes under section 50, within bracket 1 of the CGST Act. Post of. It had only made a prayer through its representation dated 6/2/2024 to allow it to deposit the amount of rupees 96,06,286 in 48 equal monthly installments on the ground that if it was asked to deposit such amount within a short period, its business would be severely affected. Full stop. The petitioner firm was also asked to provide the details whether it had paid rupees 19 lakh or rupees 28 lakh in form DRC 03. Full stop. The respondent authorities in its letter dated 22/10/2024 had provided the details like the date of deposit and the amount paid through DRC 03. To state that as per their records, only an amount of rupees 19 lakh was paid. First of, the petitioner had not the said position is was again reiterated in the letter dated 28/11/2024. Post of. The petitioner has not responded to any of those two letters. Post of. The section 50. Sorry, section 80. Has provided that the commissioner may, for regions to be recorded in writing, extend the time for payment or allow payment of any amount due under the CGST Act, other than the amount due as per the liability self-assessed in any return. That is the ground.
That's why, I mean, this, they have quantified not from return, they have done the calculation, this amount was not reflected in the return, my lord.
On an application filed by a taxable person. Oh, sorry, by a taxable person in monthly installments, not exceeding 24, subject to payment of interest under section 50 and subject to such conditions and limitations as may be prescribed, on an application filed by a taxable person. So it was provided, it is further provided that, it is provided that, where, no, sorry, the proviso to section 80 has provided that where there is default in payment of any one installment on its due date, the whole outstanding balance payable on such date shall become due and payable forthwith, and shall, without any further notice being served on the person, be liable for recovery. Where in view of such statutory limitations, vested in the commissioner, this court finds that the rejection of the prayer of the petitioner to deposit the demanded amount in 40 equal monthly installments is not inconsistent with the provisions of section 80 of the CGST Act. First of. Mr. Mishra, learned counsel for the petitioner, has submitted that another ground for rejection of the prayer to deposit in installments was that the amount the demanded amount was quantified. With regard to self-assessed liability self-assessed in the returns, during the concerned period, which, comma, according to him, comma, is not tenable. Full stop. Para. Mr. Mishra, the counsel for the petition has further submitted that the petitioner is ready and willing to deposit the demanded amount in 24 equal monthly installments, and such a request would fall within the four corners of the provisions of Section 80 of the CGST Act. Full stop. He has submitted that such an, no, full stop, para. Mr. Jain, learned counsel appearing for the respondents. Respondent number 226 has submitted that in the event such an application is filed by the petitioner found, comma, the same would be considered under the provisions of Section 80 of the CGST Act within a reasonable period of time. Para. In the above obtaining, in the above backdrop, comma, Rule 158 of the CGST rules 2017 is of relevance, and the same is quoted here in below. 158, heading 22, page 538 also. As evidently the earlier application of the petitioner to deposit the demanded amount in 48 equal monthly installments is not as per the statutory prescriptions contained in Section 80 of the CGST Act, comma, the petitioner can be provided another opportunity to file, to submit another a fresh application, renewing its request to pay the demanded amount in 24 equal monthly installments, comma, as permissible under Section 80 of the CGST Act. Full stop. If it is accordingly, comma, the petition is permitted leave stands granted to the petitioner to file another application for allowing it to deposit the demanded amount in 24 equal monthly installments in terms of Section 80 of the CGST Act, within a period of 15 days from today. Also, it is observed that in the event such an application is filed by the petitioner, the commissioner, the response number 2
2, my lord.
will consider, shall consider consider such application in terms of section 80 of the CGST Act, read with section 150 rules, 158 of the CGST rules. And thereafter, issue an order inform GST DRC -21. Post of such an order, it is further observed that the order in Form GST DRC -21 shall be passed as expeditiously as possible. Any time limit?
Maybe 1 month.
Like DRC is not like order, simply order will go. Preferably within a period of, within an outer limit of 1 month from the date of submission of such application with the above, with the observations made and the directions given from under petition is disposed of. There shall be no order to pass.
Supplementary list, item number 13.
Yes, where is Mr. Ramdas? You are standing counsel.
I'm not standing, I'm appearing on behalf of Mr. RM.
We need quick action.
Lordship, this relates to non-creamy layer of certificate, Lordship. Social justice have nothing to do with that, Lordship.
Huh?
The social justice does not have anything to do
Who
with
deals with OBC matters?
OBC, we look after. But this petition relates to non-issuance of
No, who deals with OBC?
Lordship social justice.
Then your notification is creating a bar.
No, Lordship, that notification relates to caste certificate, Lordship.
Whatever, first take this one.
What my learned friend is trying to say is, Your Lordship, the objection that has come, it's only in relation to a caste certificate and not in regards to the caste
Okay,
certificate.
then.
alike. That's what he said.
Whether deputy commissioner was right or wrong then?
Lordship, in this case,
He is asking for renewal of a non-criminal certificate,
yes, Lordship.
right? And this notification is issuance of
Caste
OBC or OBC caste certificate,
Yes, sir.
social status certificate.
certificate.
And that deputy commissioner, relying on this notification, has himself issued another notification, right? And he give it to me. In both the notifications, there is mention of some Jonadari Sonmiloni.
Yes, there also it speaks about some kind of an organization who has to give a clearance, only in regards to this caste certificate issue, not criminal,
Not criminal,
not criminal.
right? Now he is asking for a criminal certificate.
Yes, sir.
So tell me whether on the pretext of these two notifications, where the deputy commissioner was justified not to issue a non-criminal certificate.
Lordship, this notification relates to only caste certificate, not of non-criminal layer. Lordship.
Huh.
So, that call has to be taken by the DC, Lordship.
And
Non-criminal,
whether then he can bring in all these Jatiyo Sonmiloni,
no, Lordship.
Huh?
No, Lordship.
then take a information from your commissioner and secretary.
If that he's saying that this is not applicable, then my certificate can be issued.
Right,
Yes.
so deputy commissioner is finding himself
Right,
in a
some-
soup that because of
Because of
this,
obstruction,
I am.
yes. It's not able to issue the certificate.
So if the commissioner secretary clarifies,
Yes.
then end of the
End
matter.
of the matter, yes.
Deputy commissioner has to take his own call. Is it not?
Yes.
That is the
absolutely.
issue.
Absolutely. If this bar goes, then the certificate can be issued. He's only on this bar, that's all.
He is apprehending that I am bound by this
Notification.
notification. So if there is a clarification,
So I'll get that.
Mr. Dhar knows that has been diluted the,
Diluted my lord. That I was on that only.
no,
I got a judgment.
I have seen, I have read now, you tell me, that was withdrawn.
Why withdrawn, my lord? I am on that. There was a PIL attached to that case. I have put the order of PIL, my lord.
I have the order of the
And
PI.
I have the rules.
Now, rule frame,
I'm coming, my lord, there. Just.
it was withdrawn and that authority was given a recommendatory role.
Rule, my lord.
Read down, that thing was read down.
Absolutely.
Now thereafter, did you bring any role? Because that notification is absolutely in conformity with this one.
In fact, in the PIL relies on Madhuri Kumari and
I have
para
read.
13. Yes, it says about para 13 that only the DC has the role, nobody else.
No, I have read the judgment, PIL judgment.
No,
Thereafter, anything new?
my lord, this PIL, why this PIL, my lord? My lord will take this rule 3.1b, my lord. That
Hmm.
is the power, my lord. From where this actually it came, my lord.
Right.
This is the
Mr.
power.
Dhar,
Yes, my lord.
So this judgment really covers everything.
come to Biraj Kohli, no?
Yes, Viraj Kohli. Item 13.
What is his issue? Where was his original certificate?
Yes, my lord. The original certificate is at page. The caste certificate is at page 42.
42.
Yes. Creamy layer certificate,
Ah.
non-creamy layer certificate is I just 1 minute. It's at page 50. His date is 26th of January 2024.
Page 50.
50, annexure 9.
Okay. Heard Mr. R.B. Fukan, learned counsel for the petitioner. Mr. Dhar, you are presently in which department? Tribal affairs. Okay, be there. Have you submitted the cost title?
Yes, we have submitted, but because the file was here, they couldn't,
Okay,
it's been submitted.
okay. Mr. C. Sharma, learned counsel representing Mr. R. M. Das. Learned standing counsel, Social Justice and Empowerment Department. Mr. R. Dhar, learned standing counsel, Tribal Affairs Department. Mr. N. Das, learned junior government advocate, Assam. And Ms. D. Bora, learned standing counsel, Health and Family Welfare Department. Para. The petitioner is a permanent resident of Assam, and he was issued a permanent residence certificate by the District Commissioner Sunitpur on 20/04/2016. Full stop. The petitioner has claimed that, asserted that the father of the petitioner belonged to
OBC Kori.
belonged to
Kori
Koiri,
community. Kori community.
Koiri, within bracket, tea garden laborers. TGL Kori Thobo, page 42. So, tea garden tribes, stroke X tea garden laborers, stroke X tea garden tribes, within bracket, caste stroke community, which is recognized as other backward class stroke. So what is short code OBC stroke more other backward class by the government of Assam. Full stop. The petitioner was also issued a social status certificate. This social status is it called social
Yes.
status?
Yes, page 43.
Social status certificate by the District Commissioner Sunitpur on 5/12/2023. First of the petitioner
It's not, I'm just, that is at page 43, 4/6/2015, that certificate was issued. First certificate that was issued. After digitalization, the other certificate was issued. The first certificate is at page 43, which is 4/6/2015.
okay,
Yes.
was initially issued the social status certificate on 4/6/2015.
Great.
So thereafter, the District Commissioner Sunitpur issued. It will be renewed then.
No, this was, this is a digital certificate because the other one was an old certificate. So
Issued.
we.
The social status certificate as OBC stroke MOBC on 5/12/2023. First one. The petitioner was also issued a non-creamy layer certificate page
50.
by the District Commissioner Sunitpur on
26/1.
26/1/2024. The petitioner had passed high school living certificate and the high secondary examination. Sorry, HSLC, high school living certificate examination, HSLC examination. And the higher secondary science examination from the state of Assam. So this is you're pursuing undergraduate.
No,
You
I've
were
already completed
okay.
MBBS on 3/4/2023.
Okay, where is the medical certificate, MBBS certificate?
Page 48.
The petitioner had thereafter obtained MBBS degree from Tejpur Medical College and Srimanto Shangkardev University of Health Sciences, Guwahati, Assam, issued a certificate to that effect on 19/8/2023. Full stop. Para. After passing MBBS examination, comma, the petitioner already over or examination?
Yes, MBBS completed. I have enrolled myself.
Aims.
Ames, no. Ames is on the written exam is on, my lord, is on 17th of May.
Has desired to pursue postgraduate course
Yes, ma'am.
in the All India Institute of Medical Science, AIMS, from the session July, 2025. And for that purpose, he submitted his application online on 30/03/2025. Session July 25. Under the OBC stroke MOBC. Under the, as a student, for the seats reserved for OBC stroke
OBC,
MOBC.
Stroke and OBC.
Category.
Category, yes.
Full stop. As there is requirement to submit a fresh non-creamy layer certificate
Yes,
for the purpose of pursuing the postgraduate course in the AIMS. The petitioner submitted the application on 30/3/2023. Full stop. Para. Any information provided
yes.
that you are not going and writing?
No, what happened is, my lord, the certificate that I submitted was though expired because the non-creamy layer certificate is valid for 1 year. Much before it expired, I applied. However, till date, it has not been issued.
That is what.
So subsequently,
The office of the district commissioner.
yes,
Did he inform, did the office inform in writing something?
yes, that's at page 52, my
Okay.
52 is the type one.
What is your comment?
Yes, the comment, my lord, is an
Ah.
official remark and comment.
Uh-huh.
Recommendation required for so and so.
When did you submit then?
The application was
Sorry.
submitted
Okay,
25th of November.
okay. Right. For non-creamy layer,
Yes,
when?
25th of November 2024. The date is written there, submitted on 25th November 2024.
Then why in paragraph 13 you have mentioned 33?
Reapplying,
Reapplied.
yes. I had to because I was not getting it. I applied in the month of November only. It was expiring. They didn't give me anything.
Or to go to 25/11/2025 or 33/2025 or title. Subsequently, the petitioner submitted another application. We don't require that this because status is given here only.
Yes, yes.
52,
This, in fact, this can be mentioned only.
not subsequent.
Yeah.
When the petitioner wanted to know the status of his application for non-creamy layer certificate, this is portal,
Yes, the
the
copies,
portal, Seva Setu.
yes.
Seva Setu.
No, this is
There was it.
Seva Station. I'm not aware of it.
There was it.
Seva Setu, she's saying.
Seva Setu. It is found that issuance of non-creamy layer certificate would require recommendation from an organization, comma, Messrs. Shah Janajati Jatiya Honmiloni, comma, Assam. Full stop. On further inquiry, the petition came to learn that petition has come to learn that there is a notification dated 5/12/2024 issued by the Deputy Commissioner Sonitpur, wherein it is mentioned that identification and issuance of caste certificate of members of tea garden stroke ex-tea garden community would require recommendation from the President and General Secretary of Central Committees or its district committees of Shah Janajati Jatiya Honmiloni Assam. Full stop. The notification mentions that such a recommendation is a mandatory document for issuance of caste certificate for the members of the tea garden stroke ex-tea garden community. Full stop. The petitioner has further come to learn that there is a notification of the Welfare of 10 Tribes and Backward Classes Department, within bracket, since abolished, dated 29/3/2022. The contents of which reads as under. লিখে দিব। It is submitted at the bar that there was an earlier notification of the WPTBC department dated 22/06/2009, which authorized the president stroke vice president of all Assam Tribal Sangha and district units of all Assam Tribal Sangha to identify the status of scheduled tribes communities and issue certificates to the scheduled tribes within bracket P and scheduled tribes within bracket H in Assam. Full stop. The statutory role provided to all Assam Tribal Sangha in the process of issuance of social status certificate to scheduled tribes P stroke scheduled tribes H came under examination before this court in PIL number 30/2019 and another repetition, comma WPC number 4840/2018. Full stop. During the course of deliberation of those proceedings before the division bench on 1/3/2023, it was informed that the notification dated 22/06/2009 had already been withdrawn. Full stop. The division bench closed the proceedings of the PIL and WBC number so and so. By its order dated 1/3/2023. With the observation that the Honorable Supreme Court in Kumari Madhuri Patil and another versus additional commissioner tribal development and another on others, 1994 6 SCC 241 in paragraph 13. Had observed that the application for grant of social status certificate shall be made to the Deputy Collector strokes Revenue Subdivisional Officers stroke Deputy Commission within bracket presently and the certificate shall be issued by such officer such shall be issued only by such officer. The division bench had further observed that an entity like all Assam Tribal Sangha can play only a recommendatory role in the process of issuance of social status certificate. Where are the issues which have arisen now are that, firstly, whether the notification dated 29/3/2022 of the WPTBC department the successor of which department is the Social Empowerment and
Social Justice and Empowerment Department.
Empowerment Department. Equal line to is still in vogue in view of the observation made in the order dated 1/3/2023 by the division bench in PIL number 30/2019. So the issue appears to be relevant because the notification dated 5/12/2024 of the District Commissioner Sonitpur is based on the notification dated 29/3/2022 of the WPTBC department. And secondly, when a person has already been issued OBC social status certificate as a person belonging to OBC stroke MOBC category and a non-criminalized certificate earlier, there is still any necessity to whether it is mandatory to have a recommendation from an entity like Shah Janodadari Jatiyo Sammiloni, Assam, on the basis of which issuance of non-creamy layer certificate in respect of the petitioner has been delayed. This is the issue?
Yes, sir.
These two.
Your Lordship, I want to clear one thing, Lordship. WPT has been WPT BC has been bifurcated in two departments, Lordship, WPT and BC.
Okay. I have said the succession, the
Social
department.
justice,
Now I have said the successor department.
Yes, sir.
I think at least for this notification, you had a,
Yes, sir.
not Mr. Dhor. That is what I said. Successor department, I said.
Yes, sir.
So you are the successor department, not Mr. Dhor, because he is dealing with tribal affairs. So when? Friday?
Okay, Lordship.
Friday.
May I just make one small request, if it is not inconvenience? This, would your lordship be kind enough to mention one thing, that this notification ultimately only relates to a caste and not creamy layer? Because
Huh?
your lordship has already said that even for reassurance of the certificate, only one line that this certificate which is there is only in regards to caste and not for not creamy layer. That will make it very clear, because that's the instruction that he'll get. That makes it clear that.
No, what,
In fact, your lordship has said that this notification may not be mandatorily, that clarification may not be required for the reissuance of a non-creamy layer certificate. All I am requesting, if one line could be added, that this notification is ultimately only in regards to a caste and not to a creamy layer.
no, we are not deciding it.
No, I'm only saying that if that observation comes, that's all. I leave it to your.
No, I am not giving any observation. We'll
I-
give observation when the time comes.
Okay, I leave it to that.
I am not giving observation right
I
now.
leave it to your lordship. I leave it to your lordship.
Lordship will fix it on 13th, Lordship, 13th,
13th.
because tomorrow is a holiday, Lordship.
Okay. Okay, 13th. You have the copy of the petition?
Yes, we've already submitted.
But as the issue is similar in item number, WBC number so and so,
15.
and same kind of clarifications are necessary. No, the issue is, the issues are similar in the WBC number so and so. So both the cases will listed
On 30.
so and so. That'll do. The name of Mr. R. Dhor be reflected in the respondent side in the cause list.
He's been made a formal party, so he'll be here.
I even something to that, my lord. For creamy layer, it is the creamy who has to take a call, because creamy layer.
No.
My lord.
No, he
the
is
wealth and the income, my lord. That is, he will fight, not.
not a single case, there are two cases now. Cases may be added later on.
Section 2E is concerned, the premises defined. The religious
Public premises.
or place of worship is not covered. And my lord, the petition number 1 is the tomb and religious. I'm not referring institution, but it is a.
As of now, my primary view is that this is an appealable order.
That's right, my lord. Question is, my
This
lord,
cannot be challenged in a writ petition.
but one of Supreme Court says, when the arbitrary and action taken, and there is a central government.
Then it is only,
Central government already notified, there is a notification, my lord. That has to be followed.
we are not here for determining these boundaries.
Paragraph 56.
These are disputed questions of
Paragraph
fact.
56, my lord. The central government, because of the criticism of use of power under Public Premises Act, the
Page,
there is a, my lord, notification.
page,
There is, I have flag mark, my lord, paragraph 56. Issued the guidelines to prevent such arbitrary use of this power. And these guidelines were issued by,
these are in the context of what?
and because
Let
my
us
lord,
see the- let us
question is,
see
my
the
lord,
case.
one, two, lordship, close to, my lord. Here to prevent arbitrary use of powers to evict genuine tenants from public premises and to limit the use of powers by the state officer appointed under section so and so of Public Premises Act 1971, it has been decided by government to lay down the following guidelines. And here, my lord, number 1, Roman 1, the provision of the Public Premises Eviction of Unauthorized Occupant Act 1971 should be used primarily to evict totally unauthorized occupants. And lordship, we have, my lord, equal right over the land. We are not
We
unauthorized.
don't know the land. We don't know the land, sir.
Question is the premises. The public premises, my lord, we have already acquired the right. That right cannot be bypassed.
Then that cannot be done by writing a letter.
No. This is a judgment, my lord, judgment and decree passed by the competent court.
Right, that cannot be responded to by writing a letter. Sending it by registered post.
Yes, I have informed, there is my submission.
Uh-huh.
I have submitted my
That cannot-
representation.
He,
and reply-
otherwise,
Reply made.
firstly, so cause notice. This notice in the under section 4 is in the form of a so cause notice.
But-
Right? Then that cannot, if you have replied by way of a letter sent by registered post,
Register post. That has,
Right.
that already received. because
received, right.
I have submitted the reply.
submitted a reply,
Reply.
and he said
And
that
so
he had considered
And
perhaps.
so far, my lord, this
Let us
impugn,
see one.
lordship, this impugn notice, page, my lord, 31, kindly have a look, my lord. Here clearly mentioned 2G. That is to be looking into account, whether 2G is attracted in this case.
Now, let us see the
2G, my
notice
lord.
first.
Kindly have
Let
a
us see the first content of the notice, one by one.
Lordship,
Let us come to page 33.
page 31. Page 31 is the notice.
Public premises Act first. Let us see what is subsection,
Subsection 1,
subsection 2
yes.
of section 4. Let us see subsection 2.
And section 4,
Section
section 4,
2 under,
subsection 1, and
because of the seal, it is not very much known. Okay, subsection 2B,
2,
B
subsection
two.
2B,
okay,
subsection 2.
a notice.
Two.
If the estate officer has informed in any proceeding.
If the state officer is of
That he should
opinion
be
that
evicted
any
as
person
well
are
as
in
issue
unauthorized
in the manner
occupation
and of the
of any
provided.
public premises,
A notice in writing
and
within
that
7
they
working
should
days
be
from date
evicted.
of receipt or information regarding.
The state
unauthorized
officer shall
occupation
issue
of the person to so
the
by
manner unauthorized.
any order of eviction should not be made. And knows and rigid with anybody and without prejudice or provision of the interpublic. Because when order of eviction should not be made. Any delay in issuing the notice and the vision proceeding, notice shall. Notice shall. Require all person concerned. So after that notice, what did you do?
Lordship, this notice was, my lord, time was fixed, my lord, to shown on 17 to 2025.
What is the date of this notice?
Notice was issued, my lord, date, that is, my lord, 20 January.
Okay,
Date.
17 2 was the date for
Date.
personal hearing.
And on the same date, it was received, my lord. But
Okay.
I made reply through an advocate This reply made on, this was prepared
PS
on,
34.
yes, page 34.
Mutawali.
Yes, my ground saying that my
Within the-
clan has been managing the said Dargah Sharif, having
Which is
peaceful
within the
position over
railway colony,
the strength of civil court order
which
long
has
back,
been under the
dated
management
6
of the client.
12/2003 in TS number
My
84
client has
90
been managing the
So
Dargah
this was
Sharif,
was acknowledged.
having peaceful position, but they are under strength of civil court order, long back dated Swansea in Target. Swansea.
And they were very much acquainted regarding this case because they appeared in the title serve number 84/98, but could not file the WS. Therefore, ex parte judgment passed. And also they will order 9 rule 13 to vacate the ex parte order. They are well acquainted. Now we cannot be treated as unauthorized occupant. Now
We are not here, sir, to determine unauthorized document or authorized document.
The question, my lord, so far.
Question is the following the procedure or not.
This notice, whether.
Let us see the order.
notice is attractive,
Let us
we
see
have
the
to
order.
understand the matter.
Then we'll come to your title suit.
Now, my lord, this notice was received on my lord, 17/2/2025, on the same day, when date was fixed, not delayed. When date was fixed for hearing on the same date, but no further date was fixed.
No, if you don't appear,
No, when notice received, but there is no any information gathered,
you submitted, you decided to submit it by registered post,
registered post.
not person. But statute says personal hearing.
But this matter was heard, the instant case expired on 12/3.
No, we-
On the next month.
Let us see first section 4 notice, your reply and section 5 order. Then we'll come to your title suit. One by one. Okay, now let us see your title suit.
Title suit, my lord, page 16. This is judgment matter. TS number 84/98. This is a suit for declaration and permanent injunction, arresting the defendant.
No,
from
page 16, come to your page 16.
16, Rosh.
Hmm.
May I read my?
Thus, you read.
The case of the plaintiff in brief is that plaintiff is the secretary and Mutwali of Hazrat Said Nabiullah Aula Mazahar, Tom, situated at Simulaguri local colony in Shivsagar district. People regularly visiting the and praying before the Mazar for peace. The said Mazar is situated adjacent to NF railway quarter number so and so, old local colony, Simulaguri. Hence plaintiff has applied for settlement of 2 kathas of land in favor of said Mazahar, including the quarter number so and so. The quarter number so and so originally allotted to former defendant Sri Bimal Borua. But as Bimal Borua has his own residential house, he used to take shelter at daytime, and as such, a part of quarter has been occupying by the plaintiff for smooth management and maintenance of the Mazar. Former defendant Bimal Borua never accept any amount from the plaintiff, nor he sublet any portion as alleged by the defendant number 2, filed letter number so and so, dated so and so. Now, my lord, plaintiff also filed application for settlement of the land before the Honorable General Manager Maligao with recommendation of Dr. Hema Prabha Saikia, MLA, Nazira. Plaintiff had also filed a petition before the Deputy General Manager NF Railway.
Typed correctly. Type correctly.
Yes, Lordship.
Huh?
Yes.
What is all this?
Tinsukia and DGM. And the certificate could be also enclosed. It was handwritten. And that her application shall be considered, but defendant number 2, unsocial element of the society, has been trying to dismantle the Mazar from 18/8/1998. And due to constant threat from the side of
Plaintiff
defendant
also
number two,
filed,
the plaintiff filed this suit for declaration and permanent injunction. Defendants appeared after receiving summon and repeatedly took
Trying
adjournment
to-
for filing written statement.
trying to
But as the defendants file the written statement, my land predecessor in office proceed ex parte against the defendants. Thereafter, plaintiff Samad Arfin Rahman filed the affidavit of examination in chief as required under order under section, it is wrong, my lord, under order 18 rule 4(1) of Code of Civil Procedure. He deposed in her evidence that she is the secretary and
he or she,
she, my lord.
Huh?
She.
This is
Petition number,
lady.
petition number 2 is the she.
huh?
Petition number 2 is she, Arfin, and Arfin Rahman.
Arfin Rahman.
Mrs. Arfin Rahman. Arfin Rahman, wife of Muhammad Abdul Rahman. She. And is the secretary and Mutwali of Hazrat Sheikh Nabiullah Aulia Mazar, Tom, situated at Somalogori, Loco Colony in Shivsagar district. The said Mazar is situated near NF Railway quarter number so-and-so, old Loco Colony of Simologori, and she has applied for the settlement of 2 kathas of land in favor of the said Mazar, including quarter number so-and-so. And she has been holding the entire plot of land for maintenance of the said Mazar and holding a part of said quarter for very long time. Originally, quarter number so-and-so was allotted to former defendant Sri Bimal Borua, but as Sri Bimal Borua has got his own residential house at Simulagori, he used to take shelter during daytime, and former defendant never accepted any amount from her as rent as alleged by the defendant number 2. Right letter dated so-and-so. Although Bimal Borua filed show cause reply to the aforesaid letter, defendant number 2 did not give any height to it. Instead, directed her to vacate the premises by demolishing the Mazar. Plaintiff further deposed in her evidence that she has applied for settlement of the land before the General Manager NF Railway at Maligaon with recommendation of local MLA Dr. Hemabura Soikia. The Deputy General Manager Tinsukia and DGM of NF Railway Tinsukia also gave assurance to look into the matter. Plaintiff deposed in her evidence that defendant number 2, along with other, trying to dismantle the tomb since 18/8/1998. As such, she compelled to file the suit for declaration and permanent injunction. It appears from the evidence on record of the plaintiff's evidence that it reveals that plaintiff has been maintaining said Mazar by performing ritual very since long time. Further, different people of irrespective caste and religion visited the tomb regularly for prayer. It also reveals from the evidence on record that pro forma defendant Sri Bimal Borua has supported the case of the plaintiff. It reveals that pro forma defendant filed his written statement by supporting the case of the plaintiff, that he never accepted any rent from the plaintiff of the said quarter, and a major portion of the said quarter is occupied by the plaintiff. From the perusal of evidence on record, it revealed that different people of irrespective of caste and religion gave an application to the General Manager of NF Railway along with Dr. D.H. Soikia MLA for settlement.
Where is your schedule?
Schedule, my lord.
Schedule?
Schedule, the plaintiff is not available with me, but
Huh?
this order itself.
No, where is the schedule?
Page 19, my lord. This schedule here describes 2 katha land of local colony NF Railway Siliguri in Shivsagar district along with the portion of quarter so of the said premises.
So how can
This
this court determine whether railway plot number 19 is commensurate with this 2 bighas at old local colony? How can this court can determine?
This land is
Because the notice was page 33, railway plot number 19, right? Under plan number so and so. cadastral tag number so and so, so and so, so and so, north, south, so and so, so and so. These are different schedule. We don't know the schedule in your title suit.
But here, my lord, in notice.
Notice the boundaries are clearly defined.
Mazar clearly mentioned 7.5 into 18.
Where?
So this is the Mazar, the demolition of Mazar. This
That we don't
notice for this.
Quarter number 34 vacant land, quarter number UH2 road.
But this title suit land is covered this Mazar.
We
I-
don't know.
We are not residing. You see, it is.
We don't know,
It is,
we don't
it is related to the Mazar. And Mazar also.
We are not here
also
for
the part.
determination of facts.
Mazar lordship.
Otherwise, this four is, you cannot say it is without jurisdiction and estate officer has the jurisdiction
My lord,
to
page
issue a notice.
page 38, my lord.
You should have laid evidence before him that no, absolutely wrong. Your issuance of notice is absolutely wrong because section 2 says all persons concerned. That is to say all persons. There is no distinction in section 2. 4, section 4, subsection 2. When the legislature has asked, we are not here to interpret. You should have let the evidence known. This notice is absolutely barred. You don't have the authority and jurisdiction. I have the decree of the title suit. This is my boundary. And your notice is with regard to this plot of land bounded by this are similar with that boundary you mentioned. You simply chew the judgment of the court. That is not.
But lordship, the notice itself reflected the schedule as Mazar.
You may be encroaching
Mazar.
more
And
than
we are-
2
we are-
kathas.
We are also in.
You
favor
may
of-
be encroaching more than 2 kathas also. We don't know.
Then my lord,
It is not possible for this court. 2 kathas you claim, yes, this is my title suit decree. You cannot touch now because your order 9 rule 13 application was also rejected, barred by limitation. So I have the absolute position of this.
Already
So you
acquired.
don't touch. You should have laid evidence. There is a law.
my lord, direction will be given to approach before the appellate authority, my lord.
You should approach because we cannot determine.
No. So
These
far,
facts.
so far liberty, with a liberty, my lord. With a liberty, because time already gone. Because within 14 days, we have to approach before the appellate authority.
Section 9 is what?
Section 9 says the my lord, within 14 days. Court proceeding. Another resolution have to put one. Section 9,
Proviso is there.
yes. Within
So
12
time spent in filing this,
within 12 days.
definitely, he is deemed to be a civil court.
Yes.
If the
District court,
civil,
yes.
if he is a civil court, then section 5 will apply. All the provisions of Limitation Act will apply.
Yes. This is.
So
yes,
you have the liberty to
Appeal
file an
after
application
expel of
along
the
with
said
condonation of delay.
Yes.
Because this can be appreciated by the appellate court.
Yes. Appeal. Before the district court, my lord. District-
Proviso is there. Provided that the appellate officer may enter in the appeal in exceptional cases after the expiry of the said period if he is satisfied for the reasons to be recorded in
Yes.
writing that there was compelling reasons
Yes.
which prevented the person from filing the appeal. So the period spent here is definitely to be considered under section 12 or 12? 12
Yes.
or 14? Or a limitation.
Limitation is written on the page 14 also, section 14 of limitation, 14 of the limitation,
14.
14 of the limitation.
You have a good case there.
Otherwise, my lord.
Why you are throwing your title suit degree by registered post?
No, that is my lord, the petitioner
14.
has taken the help from the council. Otherwise, my lord, this honorable judgment, honorable Supreme Court in Harbhajan Singh case says.
You
If-
want a
if-
judgment or you want withdrawal?
if-
Both
if-
you
if-
say.
If applicable, even though the High Court can entertain this writ.
Okay, let us then
Then
hear
my-
you. If you
but-
want an order, then we'll decide.
But if my lord, I will approach before the appellate authority because not properly narrated the schedule here, my lord. So. that
You
is-
should have
that is very-
Brought the schedule there
Yeah.
before the estate
Because
officer, then you
this
could have.
judgment doesn't say the schedule because I have no, this plaint is not available with me. So my lord, all this record I will furnish before the appellate court.
Then appellate court might remand it. Might remand it, right?
With the direction, with the liberty to approach this appellate authority.
We'll observe that this is an order under section 5 is an appealable order under section 9. So, and at the same time, we'll observe that the time spent.
Yes. And page 37, my lord, section 5, but here my typographical mistake, 6 shown.
Yes, paragraph 9 also onwards looks to indicate that part. That part was already reflected. In
Paragraph
Ravinder
nine.
Kumar Kulkar's case,
Mhm.
Ravinder Kulkar's case,
Hmm.
also already detailed discussion is there regarding. appellate
Yes,
study.
yes.
Looks like paragraph 9 onwards looks to indicate.
Hmm.
It will be calculated after that.
But difficulty is that did not lead any evidence before the estate officer disclaimed that this notice is completely illegal because I have a decree within this
So expert your right.
2 kathas,
Then also you can under section 9 also you can.
section 9. Section 9, yes.
So we can-
Definitely he has a privacy case.
Because
9 also.
order,
So he can clear all the materials before the appellate authority.
the respondent, my lord, also avail under order 9 rule 13 of CPC.
No, question is,
That
the
also rejected.
boundary we are not,
Bound, but plain, my lord, if required, but I have not a plan. But I may submit the plan, that will be clear,
you submit the plan in the appeal,
that will be clear the boundary, my lord.
that will clear the boundary because in the decree you might have the boundary.
But here, my lord.
Yes, Mr. Roy, in the decree, boundaries are defined. Title suit decree. It is a district judge who can compare. He
portion-
can compare district judge Shivsagar or Tinsukia.
Shivsagar, my lord.
He can compare in exercise of appellate power also. No, it is not
Boundary-
here. Two
bound-
boundaries, we cannot decide. In a judgment of the title suit, simply 2 kathas
And quarter,
and quarter. Which quarter? What quarter?
quarter number L/12B.
And not, they are not saying about that quarter,
with-
they are
along
saying
with-
about plot
and-
number 19.
Along with a portion, only
I heard
portion.
Mr. K. Bhuya,
This is clear.
Learned Counsel for the petitioner. And Mr. K. Gogoi, Learned Central Government Counsel for all the respondents. Full stop. Para. The petitioner have instituted the instant repetition under Article 226 of the Constitution to lay challenge to an order of eviction dated 4/4/2025 passed by the
That's one number four.
four whereby the respondent number 4 has ordered for eviction from the purported public premises. Eviction of the petition number 2
Yes.
and all persons who may be in occupation of the purported public premises or in any part thereof within a period of 15 days from the date of publication of the said order. Full stop. In the schedule
Plot number 19.
to the said order, comma, the description of the purported public premises with boundaries have been mentioned. Full stop. Mr. Bhuyan and Counsel for the petitioners has submitted that the petitioner had earlier instituted a title suit, title suit number 84/2000, 1998,
1998.
before the Court of Land, its Civil Judge Junior Division number 2 at Sibsagar for declaration and permanent injunction in respect of a plot of land measuring 2 kothas situated at Old Loco Colony, NF Railway, Himologuri, District Sibsagar, along with a portion of quarter number L/12 within bracket capital B of the said premise and to restrain
On behalf of said Mazar.
on behalf of
Hazrat
Mazhar of Hazrat Nabiullah Aulia, page 19 of the Quran, and to restrain the defendants therein from entering the said suit land. Post of Mr. Bhuyan submitted that the respondent authorities herein were the defendants in title suit number 84,
84.
stroke 1998. Post of. Though the defendants therein were duly served with the summons, no written statement was submitted by them even after their appearance, and as a result, the suit proceeded ex parte against the defendants. Full stop. The title suit was finally decreed ex parte against the defendants
on 6.
by a judgment and order dated
6,
2023, holding that the plaintiff is entitled to get a decree for settlement of the disputed land measuring 2 kathas in the, as mentioned above. First of, the defendants thereafter preferred an application under Order 9, Rule 13, read with Section 151, Code of Civil Procedure. After much delay, for vacating the ex parte judgment and order dated 16/12/2003. After much delay in the year 2015. Along with an application for condonation of delay under Section 5 of the Limitation Act 1963. Also, the application for condonation of delay
for about 12 years. Case started.
This Miss case is Miss J.
Nijji case number 7.
The application for condonation delay was registered and numbered as Miss within bracket J, case number 07/2015. And the application under section or under Order 9, Rule 13, read with Section 151 CPC, was registered and numbered as petition number
261.
261/2015. Full stop.
It was rejected.
The learned court found that the applicants failed to explain the period of delay of 12 years and by its order dated 1/8/2016, dismissed the application, Miss within bracket J, case number 07/2015. Full stop. In view of dismissal of Miss J, case number 07/2015, the case number, the petition number, no, it took Miss J, Order 9, Rule 13, not case raised on a petition number 261/2015.
Also been rejected.
In view of dismissal of so-and-so, the petition number 261/2015, filed under Order 9, Rule 13, RW, Section 151 CPC, was also dismissed.
Rejected.
Full stop. It is a contention of Mr. Bhuiyan that the judgment and order dated so-and-so had reached finality. Full stop.
And we acquired the right over the land.
And the petitioner's hearing as the plaintiffs had acquired the rights over the plot of land mentioned therein. Full stop. Para. The respondent number 4, in exercise of powers conferred by Section 4, within bracket 2, had issued a notice of the public premises, within bracket Eviction of Unauthorized Occupants Act 1971, to the petition number 2 on 20/01/2025. Stating inter alia that the petition number 2 was found in unauthorized occupation of railway plot number 19 of plan number TSK-33 L/01/2025 at SLGR Railway Colony under cadastral dark number under Moja Thupabor, measuring an area, more or less Pakka PUCCA Majar, 7.5 cross 18.0 square meter. Defined by boundaries mentioned therein. Bounded by with defined boundaries, full stop. The petitioner number 2, after receipt of the notice under section 4 of the Public Premises Act, responded through her advocate on 18/2/2025, stating that, 10/2/2025, stating inter alia that the petition number 1 had been having peaceful possession over the
My lord, it will be petition number 2 because notice was issued on behalf of petition number 2.
petition number 2 had been managing a Dargah Sharif over the plot of land mentioned in a notice, on the strength of the judgment and order dated 6/12/2003, passed in title suit number 84/1998. First off, it was conveyed that as the petitioner number 2 had become an absolute title holder of the plot of land having continuous and peaceful possession over the Dargah Sharif, managed thereon, the notice issued under section 4 of the Public Premises Act had no legal force. Post. It transpires that after sending the notice, the petitioner number 2 did not participate in the proceeding before the respondent number 4. Post. From the impugn eviction order dated 4/4/2025, it transfers that the respondent number 4 had proceeded ex parte thereafter
On 12/3/2025.
On and from 12/3/2025. Post. The asset officer appeared to have considered the documents exhibited and evidence produced by the respondent railway authorities and reached a satisfaction that the petition number 2 had been unauthorizedly occupying the subject plot of land, and hence comma, is liable to be evicted under the provisions of the Public Premises Act. Full stop. Para.
My lord, my prayer, my lord, two, four. One part, my lord, I will
We'll do that.
withdraw, but first part is to be considered one till filing of this appeal.
Para 9, please. Para 10, para 11. Para 12. Para 13. Para. The petitioner's claim regarding the plot of land
Measuring two.
where rights are acquired provide a judgment and order dated 6/2/2003 passed in title suit number 84/1998 is to be examined against the claim made by the respondent authorities in respect of the plot of land mentioned in the notice dated 20/01/2025 issued under section 4 within brackets section 4 and the order of eviction dated 4/4/2025 passed under section 5 of the Public Premises Act. Post up. The to examine such issue post up opera to examine such issue, comma, determination, factual determinations would, or no, determination of factual facts would fall for consideration, comma, first, determination of such full stop, as the description of the plot of land involved in title suit number so and so and the purported public premise mentioned in the notice dated 20/01/2025 and the order dated 4/4/2025 are not matchable, comma, this court in exercise of its read jurisdiction. It is not, it is not, it is not this court in its read jurisdiction is handicapped to decide such disputed questions of fact. And as such, this court is of the considered view that the instead petition is not to be entertained for the fact that an order passed under Section 5 of the Public Premises Act is appealable under Section 9 of the Public Premises Act before the district judge.
District judge,
Before
competent district judge.
nine. Before the jurisdictional district judge. Post of. It is a settled position of law that an appeal is in continuation of the original. An appellate court can go into can examine, can determine the issues of fact as well as of law.
When I filed the appeal. When I filed the appeal.
That is up to you. Full stop. Vera. In such view of the matter, this writ petition is not entered in. First of the liberty stands reserved to the petitioners to prefer an appeal under Section 9 of the Public Premises Act. First of it is further observed that in the event the petitioner prefers an appeal, and it is further observed that in the event the petitioner prefers any appeal under Section 9 with delay, the period spent in pursuing the present proceeding shall be considered by the appellate authority in terms of Section 14 of the Limitation Act. Post of para. Apart from assailing the order of eviction dated 4/4/2025, the petitioner has also prayed for a direction to the respondent authorities not to disturb the performance of religious affairs at
Hazrat Said
Hazrat Syed Nabiullah Aulia Mazar
on the top.
in view of the Pusto.
In respect of the decree.
Uh-huh.
6
In terms of the judgment and decree dated 6/12/2003, Supra. Post of. Having regard to the judgment and order dated 6/2/2003,
6/12, 6/12.
6/12. It is provided that in the event the respondent authorities shall not take any consequential action on the basis of the order of eviction dated 4/4/2025
25.
for a period of 1 month from today or till the date of
Filing.
filing an appeal by the petitioner, comma, whichever is earlier. Post of, it is further observed that after filing of the appeal, the appellate authority shall consider extension of any interim relief during the pendency of the appeal on its own merits and in accordance with law. So appellate court will extend.
My lord, in item number
I love-
3, petition number 1 has expired on 23rd. of
1 minute,
April.
1 minute.
So my lord.
1 minute. Let me close this one.
Oblige, Lordship.
So your first pair will be
Already covered. File of this.
item number?
3, your lordship. Petition number 1, Srimati Nirupama Talukdar has expired on 23rd. of
Okay.
April.
23rd of?
3rd of April 25.
23rd of
April.
this year. Okay.
So lordship. her
Substitution.
name is Struck off. And because already her legal years are on record.
Already there.
The registry may be directed.
But that part should be brought on record. Plus, just filing the death certificate. It will be the best part.
I'll.
If you can file it within 1 week or whatever, then we'll post it.
That certificate.
Mr. S.P. Roy, learned counsel for the petition, and Mr. B.K. Sen, learned counsel for the respondent, State Bank of India. Authorities. Mr. Roy has submitted that the petition number 1, Nirupama Talukdar, has expired on
23rd of April 25.
2025. Post of. Though it is not required to the interest of the said fact will be brought on record by way of an affidavit, but no, by way of
Appropriate.
by appropriate pleadings. He has thus sought for listing of the case after 2 weeks.
Okay.
Okay, 2 weeks. The prayer, the submission made by Mr. Roy is not opposed by Mr. Sen. Accordingly, command list the case after 2 weeks. You file that,
Okay.
then her interest is protected by the other petitioners, so then it's okay, we'll observe that.
Oblige.
For admission, item number 4.
May it please your lordship. The matter has come up today, my lord, for the first time after filing of affidavit, my lord, by respondent number 2, my lord. And my lord, from respondent number 4, 6 to 12, my lord, they have filed an IA for vacating interim order, my lord. We need some time to file a reply, my lord. To the
Just file the
affidavit.
affidavit in opposition,
Yes,
respond number
ma'am.
2,
Yes, respondent number 2 has filed.
32.
Two weeks time may be allowed, my lord.
Okay. And what is the IA?
IA is for the stay
IA by
vacating, my
whom?
lord. For vacating the stay order, my lord, interim order.
Which
In
is the
this
IA?
also, in this IA also, my lord, we want
Which
to
is the
file
IA number?
reply. 2250/24, in which we got interim relief, my lord. And IA file,
Huh? 992. Huh?
2550, 2550.
Hmm.
It's,
There they have filed objection.
yes, my lord.
So you want 2 weeks time to file an
Reply.
affidavit in reply
My lord.
to the affidavit in opposition filed by
Filed by the
the
respondent
respondent number
number 2.
2. And in the IA?
In the IA also, we want to file reply, my lord.
You are for?
For co-question different, respond number 1, 2, 3, and 4. Above West Bengal.
Okay, who is for the respond number 5 to 12?
6 to 12, my lord.
6, no, 5 also. There is 5 also.
Yes, my lord.
Okay, Mr.
As Upadhyay, I'm on behalf of Mr. B. Sinha, my lord.
Upadhyay, Learned Counsel for the, preparing for the petitioners. Heard, huh? And Mr.
K. Sudhir on behalf of SK Taluk.
K.S.
K.A. Sudhir.
Sodial,
K.A. Sudhir.
Learned Counsel representing Mr. S.K. Talukdar,
Standing.
Learned Standing Counsel, Corporation Department for the respondent number 1 to 4. Yes, Mr. P.K. Deka.
Hello, this matter we have filed one I, my lord. For
You are for which respondent?
respondent, my lord, 5 to 12.
As per Learned Counsel for the respondent number 5 to 12. Yes, what is your?
My lord, in this because I have filed one I, my lord. Regarding the modification of the interim order obtained by the petitioner, my lord. So first, my lord, the impugn order they have challenged here in this case, but in that impugn order, there is no stay order, but subsequently they have challenged another order. In that matter, my lord, after getting this order, my lord, they're fishing in their property. We have lots of complaint, my lord, but nothing has been done by the authority. So we are before this court, my lord, by so far as one.
Let us file your reply, my lord.
Let the affidavit in reply be filed in the
Yes,
main
my
WBC. If the writ petition is decided, everything will be clear.
My humble prayer, the entire matter may be heard, my lord, at this short day.
Mr. So it's Learned Upadhyay, Learned Counsel for the petition has submitted that. The respondent number 2 has recently filed its affidavit in opposition on 28/4/2025. First of, the petitioners have sought for 2 weeks' time to file an affidavit in reply to the said affidavit in opposition of the respondent number 2. First of, the petitioner, Mr. Upadhyay has submitted that the petitioner will also file an affidavit in reply to the objection filed by the respondent number 2 in IA.
I,
I have filed.
private respondent
okay.
file this, my
6 to
lord.
12.
Okay. An objection to the interlocutory application IAC number, which one?
1300.
1300 2025 within 2 weeks' time. First of, the prayers to file affidavit in reply. Aforementioned, sorry, affidavits in reply. Sorry, affidavit in reply to the affidavit in opposition of the respondent number 2 and objection to the 2 IC number so and so are allowed. First of, release the case on
Date may be fixed.
Lordship, interim order passed earlier.
the
we
interim
continue.
order
Date
passed
may be
earlier.
fixed. Can it be fixed earlier, my lord?
Then June.
29. Gift of blessing.
Highly.
Item number 5.
May I please, your lordship?
Yes.
My lord, here the case of the petitioner that his bank account maintained by the petitioner in Bandhan Bank has been freezed by the respondent authority. And therefore, this application has been filed before this honorable court to defreeze that account, Your Honor.
Who is the state respondents? On the basis of what instruction this bank account has been freezed?
My lord, an FIR has been
Let us
lodged.
see the bank affidavit.
My lord, bank has filed 2 affidavits.
Ah,
My lord,
on what basis bank has freezed the account?
my lord, an
There
FIR,
must be some
yes, my lord.
crime case.
An FIR has been lost by the bank authority,
Where is the FIR?
my lord. In my read petition, my lord, at page number 16.
Page number 60.
May I read, my lord? My lord, I, Sanjit Das, son of Bijan Das so and so, presently working at senior manager, Bandhan Bank Limited, having its office and so, Nalbari's police station duly authorized by the bank to institute the present complaint. Bandhan Bank Ltd, a bank, my lord, the relevant portion is para number 3rd. The complainant herein would like to report multiple incident of cheating, impersonation, fraud, forgery, and criminal breach of trust of faith bestowed upon the bank by its customer and the general populace. That it has come to our knowledge upon investigation by the concerned department of the bank that at least 8 personal loan accounts were opened by the impersonation in using forced identity documents. That the complete facts and details pertaining to the activities.
So in how many accounts the alleged,
My lord, total 8%, page number
how many
70.
accounts of yours?
No, my lord.
In how many accounts of yours, the alleged proceeds of crime was credited?
1, my lord.
Which one?
My lord, para 5, my lord.
Hmm.
Page 17, my lord.
Hmm.
8%.
Nalbari branch,
My lord,
Bandhan Bank.
Bandhan Bank, Nalbari branch.
Hmm.
And
So this FIR has been registered.
this FIR has been registered, my lord,
Hmm.
and the
Yes, then bank, what the bank says?
bank states, my lord, kindly query.
Where is the bank notice?
Bank did not give any notice, my lord. Therefore, I
No,
filed,
no.
my lord,
Where is the notice to the bank by the IO?
my lord. At page number,
Bank is not required to give you notice.
my lord,
Maybe they may inform you.
my lord.
Hmm.
My lord, will find at page number 35.
Yes, Mr. Das. Page 61. I
Yes,
think
yes,
of the bank affidavit.
Page 19, my lord.
No. Affidavit in opposition on behalf of the respondent bank, perhaps. You have the affidavit.
My lord, bank has filed 2 affidavits, my lord.
Filed on 9 January 2025.
Affidavit in opposition filed by the bank.
Branch manager, Bandhan Bank, was sent an information under section 91 CRPC by the IO,
My lord,
right? And there, this petitioner's bank account maintained at Bandhan Bank. He maintained 3 accounts,
3
one
accounts,
in
my lord.
Bandhan, one is ICICI, the third one is in Axis Bank. Now, petitioner's bank account in Bandhan Bank was directed to be freezed.
My lord, all the 3 accounts has been freezed, my lord. I approach before this honorable court for only the freeze the account Bandhan Bank. My lord. Sorry, my lord.
Am I saying wrongly?
No, no,
Am I saying wrongly?
no, my lord.
Then, if I not saying wrongly,
My lord.
don't interrupt.
My lord. Sorry, my lord.
Now, Mr. Das, this is a notice under section 91 CRPC. Now, what is the stage of investigation?
That, my lord.
We are yet to receive any instruction or several notice. Well, can it be after 2 weeks?
You submit your, whether you have complied with the provisions of section 91
41 months?
is the issue, CRPC.
But if your lordship.
Section 19, sorry, it's not section 19, 100.
Section 41.
Then 100 CRPC and plus 102 perhaps.
My lord.
102.
Page 19 for. Here the date is
19.
19, page 19, and excerpt to you.
Yes,
This is to inform you that the above decision, my lord, notice under section 41.
we are on section 100. That is also not correct, 102 actually. And he has to follow certain conditions. নতুন conditions. What is the date of this particular one? 29/7/2023. নতুন কোন? CRPC type, লিখন আহিছে BNSS. BNSS.
Right, my lord.
BN. What is the equivalent provision for 102 in BNSS? Oh, BNSS coming 1/7/2024, not required. Yes, 102. Madam, 102 procedure complied or not complied, that's all. Investigating officer has the power
Yes.
to seize, freeze. But only question is whether he has rightly exercised the power or not, and the procedure required to be complied with were followed or not. IO is not the officer in charge, so he has to inform the officer in charge, and he has to inform the magistrate. Apparently, money has been transferred from two of the borrowers of the bank to the account of the petitioner.
My lord,
Two.
two, my lord, but one has transferred in my ICICI bank account and one is transferred in my Bandhan bank account. That is
So
70.
that is the scope of investigation.
My lord.
That is within the investigation.
My lord, kindly peruse the last affidavit filed by the bank here, my lord. Or my lord, the last order. The order passed by this honorable court on 19/3/2025. And thereafter, my lord, bank has filed an affidavit showing that the amount 72,000 has been transferred in my bank account, the present bank account, my lord, by one person who has taken the loan by giving false document.
Right, so be
My
the
lord,
law,
my lord, now, my lord, I would like
so
to
be the law.
I would like to submit a judgment, my lord, if your lordship permit, my lord.
Supreme Court,
My lord, the Madras High.
don't show Madras High Court. I know what the Madras High Court has directed. Any Supreme Court?
No, my lord. Only I have collected the Madras High Court.
One set of instructions have received, my lord, but it doesn't explain about the 102 proceeding, but so far as irregular.
You show me, the IO should file an affidavit. Or the officer in charge or SP should file an affidavit whether compliance of 102 was done or not. If not done, everything goes.
We are only mentioned regarding irregular transactions that have been made to the petitioner's account.
What the Madras High Court said,
My lord, to
lien,
operate the bank account and to maintain that the disputed.
minimum amount. Lien.
Right.
Lien. Allowed to operate,
Operate, my lord, and he said
keeping that particular amount in balance.
balance.
But 102 is there. Procedure is complied.
Well.
That direction may not be
And
there. But if the magistrate is not informed, it goes. Heard Mr.
DJ Haloy, my lord.
DJ Haloy,
DJ, my lord.
D for Delhi.
Well.
Land Council Board of Petitioner. What has happened to your criminal case?
My lord, I have appeared before the investigating officer after service of notice under section 41A, my lord. And now till date, that investigation not complete.
Which for the bank?
I'm sorry.
Miss M. Borman, Learned Junior Government Advocate, Assam, for response number 1, 2, and 3. Full stop. Person 2. The order dated 19/3/2025. The respondent, Bandhan Bank authorities, have filed an affidavit, an additional affidavit, on 10/4/2025, stating inter alia that there was one transaction in the Bandhan Bank account of the petition on 8/3/2000, Bandhan Bank account of petition, which has been ordered for freezing, on 8/3/2022 for an amount of rupees 72,000. Full stop. Para. From the affidavit in opposition of the respondent Bandhan Bank authorities, filed on 9/1/2025. It transfers that the concerned bank account of the petitioner maintained at Bandhan Bank, Nalbari branch, has been freezed pursuant to instruction received from the police in connection with Rongia Police Station case number 62/2023, registered under section 120B/419/420/468, IPC. Full stop. The respondent authorities, respondent number 1 to 4 shall file an affidavit, shall file its response with regard to the present status of stage of investigation of Rongia Police Station case number 62/2023, as well as about compliance of the procedures under section 102 CRPC with regard to freezing of the account of the petitioner maintained at Bandhan branch, Nalbari branch, within 2 weeks from today. Specifically 102. Raise the case on. Okay.
Item 6 and 7.
Six and seven, so.
Wait, please, your lordships. Well, on 12/9/3/2025, my lord, the honorable court has directed
No, in item
6, my lord.
1409.
Yes, my lord. And my
Is
lord,
what is,
same petitioner, my lord.
no, petitioner is same.
Same, my lord.
How these two are clubbed? One is bench 4, one is bench 5.
My lord, earlier
OS.
that has challenged,
Huh?
that has put to challenge, my lord.
No, what are the prayers?
Prayers, my lord, in present case, my lord, the,
Consent to establish.
yes, my lord. That was, my lord, cancelled, withdrawn, my lord.
Consent to
Without
establish.
affording any chance
It's
as well
not
as violation.
Roasted. Oh, that formula 10189. Mr. Burua, you will be knowing better.
Yes.
This Bricklin,
The first is that it is the order passed by the deputy commissioner whereby they have been asked to stop it.
no, I am saying bench 4 or bench 5.
This is bench 5.
Show me.
Fine.
Earlier one is bench 4, Bricklin. Now that residuary provision 10189, everything comes. And there is a note always in the cause list that council should adhere to notification number so and so. Now all this 10189 is not available. Everything you put it in 10189, everything comes to me. Mr. Soronia, everybody puts 10189, everything comes to me. Huh? I'll be dealing with other subject, roster of other case. This is what is happening. This is what is happening. Now I am strict nowadays. You put 10189, your clerk puts it, and it comes to me. Licenses and permissions, bench 4. If it is not covered, then bench 5. But if it is covered, then it goes to other benches.
Previously, it was bench 4.
So 101,148. Notification song. It is related to Bricklin. Sound.
Well, it
Huh?
10148. 10148 other settlement.
Huh. 10148. Yes. Earlier 10148. WBC number 50 of 2025. And this one is
1409.
1409. You put it 10189. And licenses and permissions, all these are bench 4. Let me see my,
It is 148, 50 to 148 is. It is 148 years, it's same years. Even it is just specially created.
আজকে যে কনস্টিটিউশন লেখা থাকে না directly. The person should adhere to all this. So, may refer to notification for any clarification regarding classification of bench 4 and bench 5 better. Other subjects. What is the prayer? Such a service as an impugn letter issued by the so-and-so withdrawing consent to establish. Measure not to cause an Bricklin. Apparently it is bench 4 matter. Mr. Borua will be knowing better. Pollution Control Board. Bricklin. It pertains to which bench?
Bench 5 takes many of the matters. So I have been dealing with so many matters in bench 5.
Okay, then we'll take
So,
up.
because others may be in the category of others 10148. 10148, that is the code.
That goes to bench 4.
Here, from this one, we can make out it is bench 4, but normally.
Earlier one is bench 4.
And here also it is. the
There
same.
could be many regions,
Ah,
which I should not say.
yes, I understand. But here also it is the same code has.
There is a word called FORUM. Council,
My lord. I
you
have
cannot
put-
say you don't
My
know.
lord, I have put the same code, my lord, 1014.
No.
48.
In the second one, you have put 10189. In the first one, 10148. Why?
My lord, both of them, my petition, my lord, it is in the category of code, my lord, I have written the same. my lord. I don't know where. is the-
No?
Yes, my lord. 10148, both of them, my lord.
I am finding it not the single instance. I have been finding it.
First page, my lord, of the read petition, my lord, post that will starts now.
So yes, for. Counsel for the petitioner, Mr. Pothagur.
Forest Department.
I Pothagur, Forest Department, Standing Council. And Ms. Hazarika, G. Hazarika, Revenue Department, Standing Council, Revenue Department. Mr. S. Borwal and Standing Council, Assam State Pollution Control Board. For the response, first of inner repetition, comma. The category of food has been mentioned as 10148, comma, which pertains to bench 4. So however, comma, the repetition has been listed. So in the particular WBC number 1409/2020. However, comma, the category code has been changed subsequently to 10189. As a result, so as a result, comma, the repetition WBC number 1409/2025 it is listed has fallen in the roster of civil bench 5. Post of the previous repetition of the same petition pertains to same subject matter was under is under category code 10148 and the repetition previous repetition WBC number 2025 50 of 2025 and the repetition is given allotted in a roster of civil bench 4. Post of the registry shall examine the reason for changing the category code of the writ petition number 1409/2025 from 10148 to 10189, which is otherwise a residual category code. Post of and post of both the cases we listed thereafter before the appropriate bench in the next week.
Right.
This is not, I have seen 100 cases.
What happens to me because
This is happening. Despite a clear indication in this particular at the bottom. All concerns should refer to notification number so and so, meaning that by council as well as the registry officials, but they are not following it. As a result, you will find
overloaded.
30, 40 motions every day.
Yes.
Before this court. 10189 is panacea of all ills.
Other matters.
For hearing, item number 8.
Yes, anything further?
Already I have submitted the list of citations, Your Lordship, on the last
Okay,
occasion.
I'll go through. Others may go then. Yes, Ms. Deka, you have any other case? I'll decide this.
Next, it is mine.
It will take time.
List after 4 weeks, madam.
Which one?
Item 9. I have to ask function of petitioner because the conducting layer was under survey.
Conducting lawyer. Who is the conducting lawyer? Huh?
That's one number 7. I am also there in this case.
What is his name?
P. Ahmed.
P. Ahmed. Okay. M. Horonia. Agreed. M. Horonia Learning Council for the petitioner. J. Ahmed heard, huh? Are present. Mr. Ahmed has submitted that the conducting council, Mr. P. A. Ahmed. Conducting council for response number 7. Mr. P. A. Ahmed has undergone surgery recently in Delhi, Chennai, and has on that ground, Mr. Ahmed has sought for listing of the case after 4 weeks. Mr. Horonian Learning Council for the petitioner, considering the grounds cited, comma has not objected to the prayer. Post of Ms. M. Borman, junior government advocate, oh, and state junior government advocate for the respondent number 4 and 5 is also in attendance. Also, list the case after 4 weeks. You are there? RM Deka, Miss RM Deka, Leonard Council, Social Department for the respondent number. Okay. Newly implemented number. You give the number to the court master. Yes. Anybody else? Anybody in item number 11? This will not be taken up today. Are you ready? Not ready? Okay. You are Mr.? Where is S.C. Bora? His name is not there? Okay. Miss S.G. Bora. Okay, Mr. B. Bora. Learned counsel representing Mr. S.G. Bora. Learned counsel for the petitioner. Under request. List the case after 2 weeks. Yes.
May it please your lordship. On the last occasion, I submitted the list of citations, I mean, the bunch of citations.
Bunch of citation.
Not,
I will not refer to bunch of citation.
no, it is just 2 and 3.
Two. Confine it to 2.
Only 2.
Your best one.
Each one is above the other.
Which one?
In my
Tell
humble
me.
sum- The first one is
List of citation. One is
1988.
Whirlpool.
1998
Whirlpool.
Whirlpool.
For what proposition?
That is basically the writ petition lies for enforcement of fundamental rights or for violation of the principles of natural justice. Now, in-
Fundamental right. Which one is your fundamental right?
in the sense that since the demolition, your lordship also indicated on a last occasion that there is no scope for compensation that I could claim.
No, because of lack of
Exactly,
sufficient factual details.
exactly.
Right.
So,
This court is not in a position to say something. Had it been, say, insurance or something like
exactly,
that,
that is it.
surveyor's report,
Yes.
it could have been. Otherwise, it is very difficult.
Difficult.
for that.
And I appreciate your
Yes.
lordship's concern.
And we have also found the state has said that you are still in occupation.
Yes, we are in occupation.
So the demolition part only remains. So you are not evicted.
Whatever the demolition that had initially taken place,
Is it
that
your
was not
case?
in accordance with law.
Is it your
Your
case?
lordship also indicated
No,
on the
no,
last
that is
occasion.
why
Your-
when time flies, people get wiser.
Yes.
What is your case? That there was demolition.
Yes,
That is one.
one.
And whether there was eviction.
The,
Two things are different.
yes, 2 things are different
Ah.
because
Whether both happen or only one happened.
as of now, only one had happened because the demolition had
So
taken
then,
place. I was,
should we decide all this? Because you are having the occupation on the basis of a mutation entry, right? If we deal with it, just I am giving the option. I have the option. I am giving you the option. If I deal with it, I'll deal with the mutation entry. And what right carries with it, right? Because you are claiming everything on the basis of that mutation entry. That is one part. Demolition part, you leave it aside. And they are claiming on the basis of some documents
Mhm.
about right, title, and interest. I am also not in a position to decide on their right on the basis of those documents in the writ proceeding. Right? Whatever, any kind of eviction process is to be done. You are still in occupation.
In occupation.
State has said. Mr. Das has said. Come to the affidavit.
The last
I'm
one
just
was-
putting the, otherwise I'm ready to dispose it of. I don't know in whatever way it go. But affidavit in opposition filed on behalf of the respondent number two.
Two.
Meaning thereby Revenue Branch Office of the District Commissioner. Filed on 29 November 2024. Paragraph
3.
3. The present status of the land is that a coke bhatta is still running in the said plot of land till date. So, on verification, it is found that land area 2 biga 1 kata 4 lesa is recorded in the name of Royal Coal Products. Owner namely Kshitij Devnath. Huh? Ah, whatever. This petitioner number 2 perhaps.
Yes.
At the concern of whether the concern falls within the schedule of Coal Mines Nationalization Act 1973. There is no record. Neither the case of the respondents is it clear, and not on the basis of your mutation entry, your right title interest is endowed. So everything goes to back to square one. Anything is to be done if this land falls in the category of public premises. Proceeding is to be initiated by the estate officer under the Public Premises Act. If it is a government land, allotted in the name of so and so, if the circle officer or district commissioner is authorized for eviction, settled procedure is to be followed. And if you want to claim declaration of right title and interest, then you have to go to the civil suit.
court.
So take your call. I'll proceed. I am putting the thing to you. Otherwise, I'm ready. And everything will be, all these points will be dealt with, right or wrong.
Your Lordship may deal with.
Huh?
Deal with.
Okay. Okay, your judgment then. Your judgments,
Yes.
Whirlpool. Tell me on what point?
Whirlpool, paragraph 15. I'm
1
reading
minute.
Paragraph 15.
15.
Page would be page 10.
15,
The internal page would be 10
15,
of that
1
compilation.
minute. 1 minute, 1 minute, let me. 15.
It deals with, it starts from page 9, paragraph 15.
Those four things.
Yes.
Those 4 things. Fundamental right, natural justice, all those.
Yes, Your Lordship. It starts from paragraph 15 at page 9.
Huh?
Under Article 226 of the Constitution, the High Court, having regard to the facts of the case, has a discretion to entertain and not to entertain a writ petition. But the High Court has imposed upon itself certain restrictions, one of which is that if an effective and efficacious remedy is available, the High Court should not normally exercise its jurisdiction. But the alternative remedy has been consistently held by this court not to operate as a bar, at least in 3 contingencies, namely where the writ petition has been filed for the enforcement of any fundamental right, or where there has been violation of the principles of natural justice, or where the order or proceedings are wholly without jurisdiction, or the virus of the act is challenged.
In what
Now-
context now?
Now, I am coming before your Lordship regarding the violation of natural justice, in as much as, because so far as the demolition is concerned, I am under the, I have a right to be heard before they take the call on. So in that view of the matter, my fundamental rights have been violated by the authorities concerned. Even assuming
Natural justice.
natural justice.
So prior opportunity being heard was not.
Yes, exactly. And I have stated in my pleadings in my writ petition as well, Your Lordship.
Okay, prior opportunity of being heard was not.
Not given. I'm just cutting short, your lordship.
Then,
So far as the other decisions are concerned,
uh,
that is in respect of state cannot forcibly disposes by an alternative order fiat except under authority of law. Now, under this heading, I am lordship
which
first coming
judgment?
to
Which judgment? Which judgment?
AR 1924 Privy Council 144. Here exactly the paragraphs are not properly marked the way it should have been. Only thing your lordship will come to internally it shows page 42, but that it may not be very visible. Page 42, the page number is referred somewhere in the middle of the page. In the next page, it is again mentioned in below page 43. So that is not uniform. I think your lordship will have to skip. The sixth page. The sixth page,
Any
the overlay
paragraph?
portion. The
Page
paragraph
42 I have
numbers are
seen.
also not, yes, your lordship, the paragraph numbers also not mentioned here in this online decision. Actually, I could not lay hands in the original.
Okay, then AIR Supreme Court 1961.
1961, I'm relying on paragraphs 11, 12, 11, 13 and 15. 11 is something to do with the facts of the case
Hmm.
regarding some land. Now, your lordship will just come to the last line of that paragraph 11.
Hmm.
A trustee, even of a public trust, can be removed only by a procedure known to law. He cannot be removed by an executive fiat. It is by now well settled that the maxim which is annexed to the soil goes with the soil has not been accepted as an absolute rule of law in this country, Paragraph 13. As to the second argument, there's argument, I'm just coming to this part first. It is enough to say that it is unnecessary in this case to determine any disputed question of fact or even to determine what precise right the petitioners obtained by sanction granted to their farm in 1909. It is enough to say that they are bona fide in possession of the construction in question and could not have been removed except under authority of law. The respondents clearly violated the fundamental rights by depriving them of possession of the Dharamsala by executive order. Those orders must be quashed and the respondents must now be restrained from interfering with the petitioners in the management of Dharmashala, temple and shops. A writ will now issue accordingly. Before we part, paragraph 14, with this case, we feel it is our duty to say that the executive action taken in this case by the state and its officers is destructive of the basic principles of the rule of law. The facts and the position of law thus clearly are, number one, that the building constructed on this piece of government land did not belong to government. Two, that the petitioners were in possession and occupation of the building. And this three is important, that by virtue of enactments binding on the government, the petitioners could be dispossessed, if at all, by only in pursuance of a decree of a civil code obtained in proceedings
How
properly
three is
initiated.
applicable? How three is applicable in your case?
No,
By
I'm, no,
virtue of
I'm
enactment-
saying,
Yes, one and
even
two
if,
is okay.
yes, even if
One
I'm
and two is
assuming,
okay.
Yeah.
But how by three? By
No, I'm
virtue
saying-
of
no, no,
enactment,
no,
binding
since-
on government.
no, what I'm saying
Nothing
is,
is binding.
no, no, even I'm saying because even if it is a civil court order,
The question of civil code does not come in your case.
no, why I'm saying is that,
Because your name was entered into the records of right by way of a mutation entry on the strength of possession. You have not been able to show any title deed. It has not come to you by way of inheritance. Right? These two are not there. And mutation entry is what? We'll observe. It is for the collection of revenue. Nothing more, nothing less. It does not give you right, title and interest. Right. The question whether it is a government land or a public premise, that is not possible to be determined by in this writ petition on the basis of the facts
Available before.
available before this court. It is for the revenue authority to decide whether it is a government land or it falls within the definition of public premises where the right of the estate officer belonging to
The
the
respondent authorities.
corporation can be exercised. This much is to be left to the discretion of these authorities, right? If it is public premises, then it has to be under the Public Premises Act. If it is not, it is a government land, then it is to be exercised by the
By the
revenue
revenue
authorities under the Assam Land and Revenue Regulation. Thirdly, if you want to have a declaration in the right title and interest,
Civil court is the alternative.
then approach is not before this court.
No, definitely, it is not before this.
It
court.
is in another forum. And that's all. And as on that, you are still in position. Running, I will not say about running
No,
the factory.
initially, may I just place it before your lordship, one thing.
And one
Initially,
more, then what more judgment? These are
one more
street?
judgment, 2002, 4 SCC 134. I'm on relying on paragraphs 10, 20 and 23.
I don't have that.
I
2000,
think it is in the compilation itself,
okay.
last one. Page would be 140 of that internal page,
You say the paragraph.
paragraph 10.
Then,
Paragraph 10, paragraph 20. Here it says about the specific statutory provision.
okay. Mr. Das,
And
your
paragraph
action,
23, yeah, I'm lordship.
this is the,
Just a background.
Mr. Das, your action on the date of demolition appears to be high-handed. Page, running page, can you say running page?
No, in this, may I just interrupt one thing, your lordship? What has happened? The respondent authority, the Coal India authorities, they approach the district administration. that
There was a
they-
meeting in
meeting-
presence of minister,
Uh.
then direction,
There
then
was some political pressure. Could be.
paragraph, let me see paragraph 7. Of respondent number? I am proceeding on the basis, if I not complete, I'll proceed to roll over, I'll not keep it part. Save
No,
it.
I think your lordship can conclude it. If need be, I can just only submit it. It can be reserved also. The judgment can be
Respondent
reserved.
number
3.
44.
Respondent number 3.
Jugal Krishna.
Jugo Krishna
Yes,
Rajbangshi.
yes, yes. Paragraph,
3.
he is referring to paragraph.
Situation has been done with regard to the litigation case. And
Regard,
paragraph 7, my lord,
the reponent status, where is all the detail.
Virodhi Patra, below annual grant. So I think I can give you this. Along with Patra, both of them measure legal 1/4 of 4 days.
Paragraph 7.
7 and
No, which you are referring to? Paragraph 3. Okay.
3.
The name is recorded at serial number so and so, PP Pata number so and so. NLR grant
this litigation case.
with a patta there. But he was in possession.
Affidavit also stated.
And
Para 7 says that you have an order passed by the duty commissioner. Case has been detailed, only to look after the law and order.
but
It is,
looking after law and order, you cannot demolish coke bhattas, which was functioning after getting permission from authorities on that land.
still, only the authority of. If you look at the para 9.
Para 9, that straightens the position.
Can carry out that authority to Coal India Limited. History was only detailed from civil administration from Benjamin Joy and all.
And what is the response of the Coal India Limited? Huh?
Another book, para 10, that will be police.
Yes, somebody belonging to somebody else. On the same date.
I have an instruction, your lordship. During the last few occasions when the matter was frequently listed regarding the coke bhatta owned by B Ganesh. Here my instruction, verbal instruction was that there are 2 coke bhattas of Mr. B Ganesh. One is in respect that was already demolished and the matter has been laid to rest. Now, in that matter, what had happened? Mr. B Ganesh had taken over the coke bhatta from an earlier employee of the Coal India Limited, who was just in possession of that plot of land. Subsequently, the authorities rightfully evicted him from that plot of land. In an earlier occasion also, my learned senior friend had submitted before the Honorable Court that B Ganesh matter has been laid to rest because it has been held that he is not that. In fact, that is the factual position.
If it's 5 years, no, for the para 8, it last process. It says, my lord, whether the concerned and force to be the city of the whole file. Estimated like 1973, no particularly respect the Makun Corporate. Can only be asserted by the concerned authority there is NSC, the name is not recorded in the name of Makun Corp will in the records of rent.
They have said in their affidavit, despite repeated requests, it is not done by you.
In
That
fact,
is-
after this affidavit, on the last occasion when this matter was listed before this Honorable Court, I personally took the initiative to call the petitioner here. And I asked him that why is not the government authorities saying specifically that this land is theirs, this land is yours. They said that whatever land Coal India authorities had, he had been informed by the office of the Deputy Commissioner, some ADC or that whatever land Coal India has, it is there. We have demarcated it, we have allocated it. Whatever is not outside that, whatever is there outside, we have not said it on record because there cannot be a record.
Okay. Yes, Mr. Ahmed, anything to add? Anything?
It is while you still on the ability of the government. History. My learned friend was pointing out to paragraph 7, and thereafter, where they say that they only were present to ensure law and order. And then at paragraph 9, even though they say everything against us, in paragraph 9, what do they say?
Paragraph 9 specifically, that demolition was carried out by Coal India. 9.
Sorry, paragraph 16.
Paragraph 16. Paragraph 16.
The deponent begs to submit that in view of the facts and circumstances as stated above, the instance this petition is devoid of any merit and hence the same life.
Same thing is said by respondent number two.
Yes.
That is in respondent number two's affidavit or three's affidavit?
Three.
Same thing is said by respondent number two also. Demolition was proposed and carried out by the Northeastern Coal Authorities.
I'm not on that. I'm only saying, in the facts of the case, ultimately, the government also says the writ petition is not sustainable.
That is something very innocuous, your lordship. In all forums, we just added a line when we are in the respondents that is liable to be dismissed with
Everything-
exemplary cost. That by itself.
We'll go whatever is on the record.
Yes.
But the act of demolition appears to be high-handed. That declaring and adjudging the unauthorized demolition of the business premises, that appears to be high-handed. Without any notice, suddenly you enter into the area. And from the records, it is not clear. So it is appears to be high-handed, but remedy is before this.
Those observations may be given so that tomorrow neither their side, our side should again come to the court again. Let it be
Following the
authorities, the stakeholders, the district administration, they should demarcate
The
the things and they should straighten the records.
Let me place the case of the petitioner, thereafter I'll hear you. So such a old case. Let me go through his pleadings and dictate it.
Then I'll make my submission.
Sure, in the meantime. The invoking the extraordinary and discretionary jurisdiction under Article 226 of the Constitution. The petitioner had instituted the present writ petition seeking entirely a direction that the demolition exercise carried out in the business premises of the petitioner number 1 farm was illegal and unauthorized. Full stop. Not full stop, comma. As such acts had resulted in the deprivation of the petitioner's right to property guaranteed under Article 300 capital A of the Constitution. Full stop. The petitioner has also sought for a direction to the respondent authorities to pay adequate compensation to the petitioner to the extent of rupees 3 crore for the alleged illegal, arbitrary, and unauthorized actions towards demolition of the petitioner's business. Petition number 1 forms business premises. Full stop, para. The petitioners have stated that the petition number 1 is a proprietorship, sole proprietorship concern, wherein the petitioner, is a sole proprietorship concern, and it had installed a what do you say? Coke?
Coke oven.
Coke?
Coke oven. Coke oven. OVEN.
Coke unit or what? What do you say it?
Oven. OVEN.
Oven. What are these documents are saying?
Page 21, annexure 1. Office of the Ledo Coilery, Gaon Panchayat.
No. What does it say? Coke manufacturing unit.
Coke manufacturing unit.
Ha.
And for a allied product.
Ha. Coke manufacturing unit. In the land purportedly belonging to the petition number 2. Full stop. The petition number 2 is the sole proprietor of the petition number 1 firm. Full stop. The Coke manufacturing unit is stated to be on a plot of, is stated to have been set up in a plot of land located in a village that's Lido Tirap Gaon, within brackets Sail Line, SAIL, then line, LINE, bracket close, comma, subdivision Margarita, comma, district Tinsukia. Close stop. The petitioners have claimed that the petitioner in the manufacturing unit, it used to produce coke and other allied products. Full stop. To support the fact that about the coke manufacturing unit, the petitioners have annexed petitioners have stated that no objection certificate to install it was obtained from the jurisdictional Gaon Panchayat, Ledo Colliery Gaon Panchayat on 5/9/2007. First stop. The coke manufacturing unit was also, a certificate of registration was also obtained from the Office of the Assistant Labor Commissioner, Tinsukia on 20/05/2009. Full stop. An acknowledgement certificate dated 4/6/2010 was also issued in the name of the petitioner number 1 firm by the District Industries and Commerce Center, Tinsukia, Full stop. The petitioner number one firm also obtained a certificate of registration on 17/8/2011 under the provisions of the Assam Value Added Tax Act 2003 niki? Para. The petitioners have claimed that the coke manufacturing unit was installed in a plot of land measuring 2 bighas, 1 katha, 4 lessas within Dag number covered by Dag number 160 and periodic patta number 2 within bracket new, situate at village Ledo Tikok number 2, NLR, Mauja Makum, Margarita subdivision, district Tinsukia, subject plot. Full stop. It is claimed that the petitioner number 2 is the owner of the subject plot. Full stop. To support such contention, a Jamabandi within bracket records of right, a copy of the Jamabandi, a copy of a Jamabandi, records of right issued, has been annexed to the writ petition as Annex 5. Full stop. Not full stop, and an entry recorded in the said Jamabandi has been relied upon. Entry full stop. The petitioners have asserted that land revenue in respect of the subject land was paid up to the year 2013, that's 2014. Post. The petitioners have further stated that the coke manufacturing unit was registered under the Finance Act 1984 read with the Service Tax Rules 1994. And a certificate to that effect was issued by the Superintendent Service Tax Cell, Digboi, on 3/9/2012. Full stop. The Pollution Control Board Assam Where is Mr. Borua? Borua is not available. had granted consent to operate the coke manufacturing unit for the period 1/4/2012 to 31/3/2013 under certain terms and conditions. As per the terms and conditions mentioned therein, the petition number 1 firm was also registered as a recognized bidder with Messrs MSTC Limited. By the license granted up to 2/4/2013. No objection certificate issued earlier by the PCBA was subsequently renewed for the period. No, sorry, an application submitted for renewal of the no objection certificate for the period 1/4/2013 to 31/3/2014 was pending consideration before the PCBA authorities on the relevant date. Full stop. Para. The relevant date, according to the petitioner, was 26/7/2013. Full stop. The petitioners have asserted that on 26/7/2013, the respondent number 2, 3, 4, and 5 from the respondent district, from the respondent Tinsukia district administration authorities, along with the respondent number 8, 9, 10, 11, and 12 from the respondent Coal India Limited authorities, paid a visit to the business premises of the petitioner number 1 firm on the subject land and demolished the entire business establishment along with all its structures and machineries standing thereon. Post stop. It is the case of the petitioners that such act of demolition was without any prior show cause notice. Post stop. There was no opportunity there was, the petitioners were afforded no reasonable opportunity of being heard prior to such illegal, arbitrary, and unauthorized act of demolition. First of para. The petitioners, it is stated that regarding the incident dated 26/7/2013, a first information report FIR was lodged by the petition number 2 before the respondent number 7 on 26/7/2013 itself. But, the respondent number 7 declined to accept and register the said FIR. Thereafter, the petitioner had to send the FIR to the respondent number 7 by registered post. The petitioners have claimed that the respondent authorities in the Coal India Limited wanted to dispossess the petitioners, who were the recorded patadars and lawful owners of the subject lot having right, title and interest for their own vested interest of setting up their own establishment on the subject lot. With such projections, the petitioners have contended that there was clear violation of the right guaranteed under 300A of the Constitution of India. And the alleged acts of demolition was clearly illegal, arbitrary, and unauthorized. And thus, the petitioners are entitled for the relief sought in the writ petition. Full stop. I have heard Mr. A.K. Chaudhary, the counsel for the petitioners, Mr. N. Das, a junior government advocate, Assam, for a respondent number 1, 2, 3, 4, 5, 6, and 7. Mr. M.J. Ahmed, a senior counsel. Ms. Doctor, to be recorded. Name to be recorded. Along with Ms. B. Doctor, senior counsel, assisted by Mr. A.M. Doctor, learned counsel for the respondent number 8, 9, 10, 11, 12, 13. 12. Up to? Okay. 12. You are for 13 also. Oh, you are Mr. N.K. Kolita. N. Kolita, learned counsel, representing Mr. A. Kolita, standing counsel, Industries and Commerce Department, for the respondent number 13. Mr. Borua is available. Okay. Para. Mr. Chaudhary, learned counsel for the petitioner, have reiterated in the course of his submissions, have reiterated the facts and the contentions are recorded, already recorded here in above. Post up. He has further submitted that the act of demolition was carried out by the respondent authorities in the Coal India Limited. Post up. It is his submission that there is no, it is not established that the subject plot belongs to the respondent Oil India Limited authorities.
Coal India.
Coal India. Coal India Limited authorities. Full stop. Referring to the certificates, stroke licenses, etc., granted by the competent authorities, comma referred above, comma, he has submitted that the coke manufacturing unit was being run from the subject plot, and as such, comma, there could not have been any act of demolition without any prior notice. First of all, if the respondent Oil India authorities, sorry, Coal India Limited authorities had claimed that it was the subject plot, if it is a claim of that the subject plot belongs to it, them, and it falls within the definition of quote unquote public premises, then any act of demolition ought to have been under the provisions of the public premises eviction of unauthorized occupants, bracket close, Act 1971. First off, even it is assumed that the subject plot belongs, is a government land, then also the provisions of the Assam Land and Regulation, Revenue Regulation 1886 and the rules framed thereunder ought to have been followed. Thus, comma, the act of demolition carried out on 26/7/2023 was clearly a high-handed, arbitrary, illegal, and unauthorized action. Full stop. Yes, any more? In support
Violation
of
of-
submissions.
Yes, submissions, violation of natural justice,
I'm referring
equity,
to,
good conscience.
without only opportunity being heard, it is already there.
Is good.
I am referring to your judgments. In support of his submissions, comma, regarding violation of the principles of natural justice. He has referred to the decision in Whirlpool Corporation versus Registrar of Trademarks, Mumbai and others, 1998, 8 SCC 1. Full stop.
Paragraph 50.
I'll. He has further submitted that it is a settled proposition that any person, even if he is, if any person in occupation of land cannot be dispossessed forcibly in a manner as had happened in the case in hand. Full stop. The respondent Coal India authorities have did not carry out the alleged act on the strength of any decree or an order of the district administration. Full stop. From the Jamabandi, from the fact emerging from the Jamabandi and the reference, it is clear that the petitioner are in bona fide possession of the subject land. Full stop. He has further referred to the decisions in Bishan Das and others versus State of Punjab and others, AIR 1961 SC 1570 and State of West Bengal and others versus Vishnu Narayan and Associates within bracket P Limited and another 2002 4 SCC 134. Full stop. Para. Mr. Das, learned junior government advocate appearing for the respondent number so and so, has referred has extensively referred to the affidavits in opposition filed separately by the respondent number 2, the respondent number 3, and the respondent number 6. Six, officer in charge.
No.
Officer in charge also submitted.
Yes.
First of all. Huh. You don't know, perhaps. Hmm? 21st November 2013.
Six.
it is submitted by him that the Tinsukia District Administration had no business in carrying out eviction in the leasehold area of what is NEC? Northeastern Coalfield of Northeastern Coalfields. Coalfield or fields? S. Okay. Comma of Coal India Limited. And was responsible only for maintenance of law and order, for which necessary steps were taken on 26/7/2013. Full stop. Let me complete, then after that you make submission. I am not completing it. Don't interrupt in between. If I remain incomplete, then you supplement it. He has submitted that as per revenue records, comma, the name of the petition number 2 was found recorded against periodic pata number 2 within bracket new of Lido Tokok, Tikok, TIKOK, 2 number NLR grant. In respect of the subject plot, along with the patadar, he has submitted that the name of the petition number 2 was recorded on the strength of his position and pursuant to an order dated 21/6/2024, passed by the respondent number 4 in mutation case number 209/2004-2005. Posto. As regards the incident which occurred on 26/7/2013, comma, he has submitted that the respondent number 2 passed an office order on 18/7/2013 detailing an executive Romanen election officer, Margherita, to maintain law and order during the time of operation for demolition of 2 coke units including the one belonging to the, including the one, including that of the petition number 1. Following the order of the Deputy Commissioner Tinsukia, comma, the respondent number, within bracket the respondent number 2, comma, the respondent number 3 passed an office order on 23/7/2013 detailing the same executive magistrate and election officer Margherita to maintain the law and order, to maintain law and order during the time of operation on 26/7/2013. Full stop. The sub-divisional police officer Margarita was also requested to deploy adequate force. Full stop. Yes, further submitted that demolition of the petition number of the petitioner's coke manufacturing unit was carried out by the authorities of the Coal India Limited. And the executive magistrate was only detailed for maintaining law and order during the time of demolition of the two coke units, one belonging to the petitioners, the other belonging to one Sri B. Ganesh. Also, both the coke manufacturing units were demolished on 26/7/2013. Yes, anything to be added?
Demolition was carried out by the whole authority.
I have said, it did not. I dictated. Huh?
Delegation to return to the original FIR is not true. They have only received the FIR audit to the register. That is.
Now, respondent number 6 has denied about receiving any FIR from the petition number 2 in person. And it has been asserted by respondent number 6 that the FIR was received only by registered post. And the said FIR was accordingly registered as Margarita Police Station case number 181/2013.
May I just point out one thing, Your Lordship, if permitted?
Yes.
This we have stated in paragraph 11 also in the writ, which Your Lordship has recorded, that they refused to accept the FIR when I approached the petitioner number 2. Situated thus, I had to.
I have already recorded.
Yes, that is what.
No,
So
I am not giving the submission. I am
No, I'm just saying it.
I am
Just-
recording his submission. Mr. Das has further submitted that other than the alleged act of demolition of the coke manufacturing unit on the subject land, there was no eviction exercise. And as on date, the petitioners are found operating Hmm. Which paragraph? Ah. Are found operating. Which paragraph? Three. Oh, I am looking at another one. Uh-huh. Were found operating its coke manufacturing unit from the on and from the subject plot. Post. Yes, Mr. Ahmed. Now, their submissions are recorded. That will decide. Leave something for me. I have already indicated what the or I'll record from the statements, right? In the affidavit. Thereafter you supplement. Thereafter you add whatever is left. I think that will be better. I'll record from the affidavit how this Coal India, coal nationalization, all this I'll record, right? Thereafter you supplement it. You add whatever is left by me.
That only thing is will also take note of the last affidavit.
We'll record everything from your affidavit. We'll record everything from your affidavit. If something is left, you supplement it. Right? Mr. M.J. Ahmed, Mr. Ahmed, Senior Counsel, appearing for the respondent, Coal India authorities, has submitted that has referred to the relevant events mentioned in the affidavit in opposition of the respondent number 8, 9, 10, and 12 as to how the subject line came to the ownership of the ownership of Messrs. Coal India Limited. From erstwhile Messrs. Assam Railways and Trading Company Limited. I'll describe the history at a later part. He has submitted that upon nationalization of the coal mines, all the assets of the erstwhile Messrs. Assam Railways and Trading Company Limited and their lands, including the subject plot and buildings and all other mining operations, stood vested in the north eastern coalfield. Huh?
In Coal India Limited.
Coal India Limited. And after being so vested, Coal India Limited has been paying all the revenues as assessed by the revenue authorities. Post of. In respect of the subject land also, Coal India Limited authorities has been paying land revenue all along, being the landholder, being its landholder. First of, he has further submitted that though the Coal India Limited authorities have been requesting time and again to the district revenue authorities to record, to mutate the name of Coal India Limited the respondent district revenue authorities did not carry out the same. First off, he has referred to a cadastral map from Annexure A to the affidavit in opposition, to submit that the subject plot falls within the parcels of land vested in Coal India Limited authorities. As the petitioner number 2 had acquired no right, title, and interest over the subject plot, the district revenue authorities could not have granted mutation in favor of the petitioner number 2 in respect of the subject plot. Full stop. The petitioner as the petitioner number 2 was found to have constructed a coke manufacturing unit on the subject plot, comma, an FIR was lodged before the Ledo outpost by the Coal India authorities on 22/05/2012. Full stop. The petition number 2 was also served a legal notice on 26/9/2012 to vacate the subject plot. Full stop. But the petition number 2, instead of receiving the legal notice, did not vacate the subject plot. Full stop. As the petition number 2 was found to have proceeded with the act of installation of the coke manufacturing unit with no intention to vacate, the meeting, the Coal India authorities in a meeting held on 9/7/2013 at Margarita, presided over by the Honorable Minister, presided over by the Minister, Power and Industries, Assam, and officials of the district administration, apprised the situation, and a decision was arrived in the said meeting to demolish, to carry out a demolition exercise in respect of the coke manufacturing plant, owned by the petition number 2. He has further submitted that officers of the Coal India Limited authorities were at the spot to ensure safe and proper functioning of the machineries, provided to the district administration officials. He has also referred to the office order passed by the Deputy Commissioner in Shukia on 18/7/2013 and order dated 23/7/2013 passed by the respondent number 3, detailing an executive magistrate and election officer to maintain law and order situation during the time of operation. On 26/7/2013. Full stop. Referring to annexer B to the affidavit in opposition, comma, Mr. Ahmed has submitted that a plot of land, a parcel of land measuring 2819B Ghas, 1 Katha, 3 lessons, covered by periodic Pata number 2 NLR, is vested in Coal India Limited. And from the Jamabandi, within bracket, record of right, annexed by the petitioner, annexer 5 to the writ petition, comma, it is evidently clear that the name of the petition number 2 was mutated on 21/4/2004 on the basis of his claim as regards possession and not on the strength of any title owned by any registered sale deed. Full stop. It is his submission that the mutation entry does not establish the right title and interest of a person on a plot of land like the subject plot. Full stop. Since there was no title, right title and interest on the subject plot, comma, the petitioners are liable to be evicted as per law. Full stop. Yes, anything to be supplemented? The history of the land, how Coal India has got the land as per Annexer B to the affidavit, I'll record in the later part. Is provide. We'll roll over to Thursday as a part heard. Not possible to complete. No, I'll record this. Yes, decisions. The later part I'll record on Thursday, right?
We had filed an affidavit on 27/1/20.
How many affidavits you have filed?
Prior to this affidavit, what has happened, the Supreme Court has directed the government revenue authorities to produce the records and documentary evidence regarding the mutation. Which was granted in favor of the petitioner. Nothing has come forth. But meantime, we have got the copy of the Patta, and we have annexed that.
Which one?
In the affidavit,
When it was filed?
27/1/25.
Affidavit in reply?
Additional affidavit.
Huh?
Affidavit in reply.
They basically filed one affidavit in response to the subsequent affidavit filed by respondent number 2 pursuant to the court order. I think the stone of some Santanu had a
Looking at. He has further submitted that when a direction was made to the district revenue authorities to find out as to whether the subject land falls within the areas of land belonging to the Coal India Limited authorities, Coal India Limited, vested from Messrs. Assam Railways and Trading Company, comma, whose name was recorded as the owner, comma, the district administration, district revenue authorities had merely observed, had expressed inability to do so on the ground of non-availability of records in their office. Full stop. Yes, this is the affidavit.
Page 52, you know, sir.
Hmm?
This is the translation copy of the, here, Miyadi.
Annexer, annexer.
Annexer.
Okay. Miyadi Patta. Miyadi Patta. Yes. Translated copy. Which part?
You see, this is, it relates to the Lido Tico NLR grant number 2.
You are concerned with document number 160.
160. And that is at page 54.
54. 54 is something else.
54 is the.
In your affidavit, additional affidavit.
Reply. No, affidavit is reply.
Reply, type copy. Okay, 54. That is running page 139. 54 is not. Okay, you tell me. Schedule.
Schedule, negotiability, doc number 160.
Hmm.
Same as the doc number they were referring.
Hmm. Okay.
Class of land is shown to be Bali
Hmm.
and the area has been shown as 11 bighas, 2 katas. In the revenue.
It is already in your annexer B. Okay, he has further submitted that from the periodic patta annexed to the affidavit filed on 27/1/2025. It is evidently clear that DAG number 160 of patta number KP patta number one of Lido Tikok village,
NLR grant number 2.
NLR grant number 2, measuring 11 bighas, 2 kathas, 12 places, belongs to Coal India Limited. Full stop. Yes, decisions. Bharat Coking Coal. H. Laxmaya Reddy.
You given the copy.
2 or 3 I have. Paragraph. I'll refer to that. 3. 3, I think.
Bharat Coking Coal.
Yes.
Limited.
Northeastern Coalfield Coal Limited.
No, that is Mubarak Ali.
Mubarak Ali. It is given to me, that is why I am.
And then just refer to the paragraph.
And also 2015-14 SCC.
Yes. In Mubarak Ali, paragraphs 8 and 9.
Okay, it is written there. He has referred to the decisions in Bharat Coking Coal Limited, Northeastern Coalfield to Mubarak Ali, and H. Laxmaya Reddy versus L. Venkatas Reddy, reported in Soil Sciences. Done.
Lakshmi.
Yes, yes, I have said.
It relates to.
Mediation. I have checked. Not be 13 or yes, 13. Huh? What is it? We'll put it on 13th.
It suits
Let
me
him
as well.
complete. Huh?
Since your lordship we earlier indicated on the day after tomorrow, it is little
No,
inconvenient.
it will not
for-
be possible.
No,
for
it is not even for me as well, so I have some personal. Let it be on 13th.
13.
Your lordship is fixing on the second half.
Will be out of state.
Hmm?
13th will be out of station. Can be 15.
13 will be better.
I think
15, so many cases. Huh?
The 13th we will need. 13th we have that problem, we won't be here, none of us. So can it be on the 15th?
15, here.
Nice.
Yeah. 20 to both clearing pieces. It is equals.
15th,
Oh.
second half, your lordship.
Wait. Oh, it's not.
Government nothing.
Okay. So, and, 2-0, but second half.
Second half. After 3 tentatively, I think that will be.
After 2 only. Not in the first half.
No.
Some 20 you have fixed one partner matter, another partner matter, council from outstation. Okay. I'm going to repeat for you. I heard from Mr. A.K. Choudhury. Land Council for the petitioner. And last, Land Junior Government Advocate Assam for the respondent was so and so লিখা আছে না? এইকেইটা যে লিখা আছিল না? As the arguments are not complete, lays the case again on 2005-2025 as part heard. Two thousand 13 case, 12 years old.
For at least 7-8 years after 2016, it was never listed. It started getting listed after 2023.
That is still enjoying.
No.